and another matter for him. Lordship, with a kindly may I mention for correction of the order dated 22 June, in which your Lordship was pleased to grant interim order against the West Bengal Fire Services Department for attempting to cancel the modular training simulator. Lordship, it has been inadvertently mentioned as GEM portal at certain places. GEM portal is not a party to this process.
Lordship, petitioner at the.
Okay, you come tomorrow. Tomorrow to be mentioned for correction.
Order has
Lordship, petitioner at the Hawker, but
Huh?
petitioner at the Hawkers, Lordship.
Hawkers.
Eviction notice issued by the NKDA on 20.
Who has issued?
NKDA, Lordship.
NKDA, what is NKDA?
Newtown Development Authority, Lordship. They said if anytime, Lordship, kindly fix the matter tomorrow, LD. Lordship, if filed after petition, they notice the eviction notice was.
Whether this court is having determination?
Yes, Lordship. This is NKDA authority, Lordship.
Not the municipal.
Not. This
So
is the
where is your
eviction notice, Lordship.
where is the writ petition?
Petition number 140.
You already filed.
Already filed, Lordship. After filing, they issue the notice, Lordship.
They issue. When the date fixed?
30th June, Lordship.
June. Where is the date? There is nothing.
No,
Within 7 days.
7 days, Lordship. But my returnable date on.
Call Ragdo within 10 minutes. Yes.
Grateful.
Have you issued the notice?
Yes, Lordship. I
issue the notice to the other side.
Yes,
Inform the matter will tomorrow.
Yes, Lordship.
Yes.
Grateful.
My lord, upon notice to the other side, my lord. I am not asking for inclusion. I am not asking for abrogation. I am not asking for fixation, but I am asking for disposal. Well, there's a writ petition against the railways. In fact, it appeared
That is
as
a
a
big one. Inclusion is small.
disposal. Disposal based on an instruction given by the railways. We are saying that your lordship can just dispose it of without any much reservation. Nothing. So we accept that. My lord, we've understood what they are trying to say, but admittedly, what fell from your lordship, my lord, when the matter was fixed, that how will the writ court decide this? So, my lord, we want to go and have it decided in the arbitration, so that recording and disposing of. If it could appear to, well, the railways matter.
It is fixed today?
No, it was fixed day before yesterday. So that, so if it appears as to be mentioned tomorrow,
to be mentioned.
Deeply obliged, madam.
I move this matter.
Well, I'll just give your lordship the cost title later.
Tomorrow to be
I will give one more notice to them,
Yes,
saying
inform
that
the
we
other.
mention them and it will appear as today.
Indian Oil, my lord, Indian Oil Corporation, my lord, floating a tender, my lord, I the successful technical bidder and the financial bidder, my lord.
Huh?
I am the technical successful bidder and the financial successful bidder, my lord. But my lord, I accept me, my lord. The other 10 numbers of contractor have been given by LOA, but no work order issued at that moment on. But
So what is your right? What is your prayer?
My lord, I am the successful bidder, my lord. Both technical and financial, my lord. My lord, leave may be granted, my lord. I move this.
No, what is your case? You have participated.
My lord.
Other 10% have participated.
My lord.
Then what has happened?
My lord, I am the successful bidder.
You are the successful bidder.
Also,
you are the L1.
My lord.
You are the L1. Successful means L1.
Successful
financial or I1, H1.
Successful financial bidder and the technical bidder, my lord.
Correct.
But those are given by LOA, my lord. They have some problem in their RTO registration in the invoice date, my lord. But the work order is issued the other no work order has been issued, my lord. At point of till today, my lord. Any point of time, my lord, work order has been issued, my lord.
So when? Tuesday?
My lord.
Tuesday?
Monday, my lord.
Monday? Yes, no.
Kindly, my lord.
ये मंडे कितना मैटर है लिस्ट में? ये कितना मैटर है लिस्ट में? Don't think. डेट वाइज नहीं रखता है, ज्यादा नहीं है ना, लेकिन हम तो yes, come on Tuesday. Monday there are several matters.
But kindly fix at time, my lord.
Monday Tuesday रखो, within 10 matters कर दो.
May I be
Issue notice to the other side.
My lord, my lord.
Without notice, I will
No, no,
not
no,
hear.
I shall.
may I be permitted to mention a matter, my lord? This is with regard to enemy property, my
Huh?
lord. Enemy property.
Enemy party.
I
Yes.
have been issued with a notice, my lord. I have filed a writ petition, my lord. It was supposed to be come.
Enemy party. What the writ petition? What is the prayer in the under the enemy
Lord,
property?
I have not been given a notice, not heard. There is no proceeding against me. Only a notice has been affixed. There are other civil disputes pending.
Who has affixed?
Lord, the BLLRO.
Hmm.
However, the enemy property authority is a different officer.
Without decision.
Without decision, without hearing, no notice to us. And there are other civil proceedings pending with other people, my lord, on that property. There are even criminal complaints that people are impersonating me.
So
My
what
lord,
is
it
your
already
right?
filed, my lord.
What is your right in the enemy property?
My lord, I have been holding that enemy property, my lord, upon lease from the people, my lord, who are the owners.
Why you not file the title suit?
My lord, but for the particular that order, my lord, I would require the interference of the writ court, my lord.
So
My lord,
what
it was
do you want?
returnable today, my lord. It was filed, my lord. If it could be
When you
listed.
filed?
My lord, we filed it on Monday, my lord.
Okay, Wednesday.
My
lord, may I be permitted?
Wednesday.
Obliged.
24th.
My lord,
First.
my lord, may I be permitted to mention a matter? My lord, this is the matter regarding the filling up of a water body. My lord, will remember have appointed 2 special officers. My lord, we have held the first meeting, but the state went unrepresented. We also tried to serve, but they are saying that it has not been allotted. No advocate has been allotted. My lord, we need an extension for filing the report and also an appropriate direction so that the state may appear, my lord.
Calcutta to be mentioned. Calcutta to be mentioned. Yes, call the list.
My lord, I am appearing for the petitioner, my lord. In this matter, I apologize for having to appear online today.
No. Considering the above, this court did not find any illegality in the impugned order of the detention date at Swanson. The writ petition is dismissed.
Yes, my lord.
Next.
Number 2.
At outset, my lord, I am grateful to Lordship that matter has been fixed as a to be mentioned. My lord,
What is the greatness in this?
Especially, my lord, I have come before the Lordship in self-same cause of action. My lord, Lordship set the precedent that any policy holder, if show the document first premium receipt to the authority of the LIC, then he is eligible to get. That is the order in the case of Kundu, my lord. Kindly have a look.
Well, this matter is already fixed on 5th of August.
That's why, my lord.
Why mentioning?
Exactly.
Lordship, that's why. My lord,
It is fixed on 5th August, 2 p.m.
Lordship, in the meantime, my lord, it would be convenient, my lord, if pass similar kind of order.
What other kind of order? Firstly, he has to.
Lordship, that is the case of Kundu order. My lord, kindly have.
That's correct, but there are 2 points of maintainability.
Lordship, maintainability ground already has been decided, my lord.
No.
By order of the court, my lord. Coordinate bench already decided. I am showing the order. I am showing the order.
Give the copy.
Lord, first of all, my lord, my learned friend did not file any Vokadnama or any kind of representation, my lord, that is showing in the record of the court, my lord.
It has. Well, Lord, NOC.
Kindly.
Well, Lord, why? What he is trying to do? Is he trying to do the matter? Then I am ready to do the matter.
I don't know.
I will show what capacity. Let him concentrate on his matter.
No, but here the two issues are there. With regard to the limitation, this court neither the respondent nor here the two issues are there. How many writ petitions?
Lordship,
Petitioners?
Lordship, in this matter, my lord, seven.
Seven.
Eight.
Seven writ petitions are having seven cause of action.
No, my lord, same cause of action.
How it can be same cause of action? In the,
But
just a minute. In the one insurance policy, all persons have taken the one insurance policy,
No,
or they have taken the different policy.
Fine insurance
Then-
policy, but cause of action is same because that is arise from the fraud committed by their own staff, my lord. That is the order, my lord, of coordinate bench, my lord, in 2024, my lord, and 2025. My lord already considered the
What, my
petitioner-
lord, he is not handing up any of the copies.
No, my lord.
How he is doing
No,
the
my lord.
matter?
On earlier
It is-
occasion, my lord, petitioner.
What you are relying upon, please serve the copy to
What
the
he's
learner.
doing-
It is the unreported judgments.
Lordship, this matter, my lord, coordinate bench passed the judgment in order in the 2025, my lord, where petitioner has been given liberty to represent before the authority. That is the thing. 1st July 2025. There is the order of Honorable Justice Partho Sarothi. Already has been represented. And they appear before the authority. My lord,
What
is my-
what you want?
Lordship,
First, you have to
Lordship,
address.
Lordship,
See, this court
Lordship.
has already fixed the matter on
Lordship.
5th of August
Lordship,
at
can-
2 p.m.
kindly see,
And you have to address with regard to the maintainability. What the judgment?
Lordship.
There is no difficulty. There is no difficulty passing an order. Yes, you are having the receipt of original
Lordship, that
receipt.
kind of-
so on,
that
they
kind
will- But the question is that this petition, how all the petitioner can file this petition
Lord-
singly?
my lord, all petitioners given liberty by this court to appear before the authority on earlier occasion.
Okay, come on that. Come on it. This, though the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner, as to be mentioned, but it is fine from the order dated 12th of June 2026. The matter is already fixed on 5th of August 2026 at 2 p.m. Let the matter appear on the fixed date.
My lord, kindly possible before
Next
that,
call.
if possible, lordship convenient, if possible.
Call the matter.
That NHAI matter, my lord, in which, my lord,
Yes.
they were supposed to file a report.
Who is appearing for the state? Today also nobody is there.
My lord, the officials, sir, they are, my lord, but
What is the report? What is the inquiry report? You had the inquiry report?
my lord, just now they served me, my lord.
My lord, may I have a copy of it?
Let me see.
My lord, this is, my lord, the original map, no?
What? In the notice was issued.
My lord, notice was issued, my lord, he was present, my lord.
No, I was present. I was present.
Other side,
ম্যাপটাই তো দেয়নি। এই plotটা। ম্যাচ করছে না তো? বুঝে গেছি ছেড়ে দে।
Yes,
Apparently wrong.
why?
My lord, kindly takes my lord the map, the
Hmm.
original map.
Hmm.
My lord, I am in possession of plot number 3.
Hmm.
Plot
Yes.
number 3 is, my lord, over here, my lord.
Yes, yes.
Now, kindly takes, my lord, the measurement given. 12, 10.97, 1.50.
Hmm.
Sorry, 2.50. And, my lord, compares it with, my lord, the report, the sketch map, my lord, given in the report.
Yes.
Instead of 12, it is now written as 10.36.
Hmm.
Instead of 2.5, it is now written as 1.984. Instead of 10.97, now
Okay,
it has
whatever it is, you challenge, but I will not grant the interim. I will vacate the interim order.
my lord,
Report is here. The authorities have reported in terms of this order.
my lord,
If you want to challenge, you go and civil suit. Take a declaration from the civil suit.
my lord, my lord, kindly consider one thing.
Decide all the thing in the writ petition, sir.
No, my lord,
The court entertained the writ application, directed the authorities to inspect. Your case was that you are not in occupation of the premises. That's why the court has directed the authority to inspect the premises in your presence as per the original map. They have so
my
you
lord,
may take any you file the affidavit, reply whatever it is, but I will not.
my lord, may I say this, my lord? My lord, today your lordship has been placed with a report, my lord, given by the authorities. Now, my lord, in the report itself,
Hmm.
if you kindly consider the joint survey report,
Hmm.
my lord, they say that there was a map presented by the HIT.
Hmm.
According to the map, it
Hmm.
is found there is an encroachment.
Correct.
Now, the map is not annexed. Instead, my lord, a sketch map is
No, map
annexed.
is there.
Map is handed over, my lord, separately.
Correct.
In the report, my lord, there is only a sketch map.
Correct.
Now, my lord, that sketch map, my lord, doesn't match with the measurements given in the original map. Apparently, my lord. Now, my lord, if this is the case, my lord, your lordship is, my lord.
Correct. That's what I'm telling. So that cannot be decided by this court whether the measurement is 12.20 or 10.30 or 4.8 or 13.92. This court cannot. If you're agreed, you go and file a suit declaring, challenging the report and whatever it is. How the writ court can now? Because you filed the writ petition, you stated that you are not in occupation of any excess land. So this court believed in your word,
Yes.
but the authority stated that they have inspected and you are in occupation. So this court specifically directed the district magistrate in accordance with the original report in your presence, the inspection should be carried out.
Correct.
Inspection has been carried out.
Yes.
Now the report has come. If you are agreed with the report, you file the exception, whatever it is. But this court will not grant. Because see, you know, you're the senior most member of the bar, and once the prima facie is that, how you are entitled to get the interim order. Prima facie is not in your favor.
My lord, may I just, my lord, if I'm correct, my lord, what is troubling your lordship?
Project cannot be installed like
No. I'm not at all saying, my lord, the project should be installed. My lord, what is troubling your lordship is, my lord, going into the factual aspect, my lord. Now, my lord, I am on a different aspect altogether. My lord, what has been given before your lordship, my lord, is, my lord, original map according to which, my lord, I was rehabilitated by the authority concerned. My lord, apropos this, my lord, today your lordship has been given a sketch map, which apparently is, my lord, absolutely different measurements. Now, today also, my lord, there is a report which says that I am in occupation of excess land.
Correct.
Now, the excess land which is being decided by the authorities is based on this map.
Yes.
Now, the map says that the exact measurements, I say that in accordance with the map and the measurements given to me, I am in occupation.
Correct.
Now, my lord, the report is absolutely and contrary to the map. This is, my lord, what I am, my lord, trying to impress upon your lordship.
Exception, you file
So, my lord,
exception, whatever.
my lord, in the meantime, my lord, if
That
your
will
lordship
decide
wants, I
If-
can, my lord, go before the civil court and, my lord, for that, my lord, a limited protection. Otherwise, my lord, tomorrow, today itself, my lord, they will go.
What can be done?
And
So
they had
if
also issued another
if you
notice.
establish, then you will go. You know what the further step. If you establish
lord,
that this is wrong and they have
Limited
taken.
protection, my lord, for some days, my lord, limited protection.
No. Oh, sorry. Come with the good case. I will give
My lord,
I have given the
my lord,
protection.
apparently, my lord, I was
Finding it prima facie. Now the prima facie is different thing.
my lord, apparently, my lord, what I was, my lord, I was satisfied, my lord, that the measurements, according to the measurements of the original map.
I appreciate your, but that can be decided by this court in the
Absolutely correct.
retribution.
Absolutely correct. Your lordship is probably, my lord, what hurdle is I am facing is, my lord, the factual aspect.
Correct.
My lord, I am ready and willing, my lord, to go before the civil court.
Go.
For that, my lord, limited protection. My lord,
My lord knows, my lord, in case of the
My lord,
project, my lord, the
3 days,
Honorable
my lord,
Supreme
3
Court
days.
observation.
my lord, today is, my lord, Wednesday. Lordship gives us time till, my lord, Tuesday.
My lord knows, my lord, in
Limited
case of the project.
When the demarcation was done, you had the knowledge with regard to the civil
My
court.
lord.
You could have
My lord, whatever.
because the demarcation was done on when?
My lord, 18th.
18.
Yes.
Then you
My
could.
lord, I had objected.
For
My lord, I had
for the-
objected to that. My lord, kindly
Maybe
consider.
objected to. Everyone objected with that. No problem.
My lord, not forcefully, my lord, the objection.
No, there is no
Attendance
question of
sheet.
forcefully. What I have seen, I have written.
My lord, that is.
My lord,
Yes.
kindly gives me.
What
My
you
lord,
want the
My lord,
repetition to be kept pending? You filed exception. I will
my lord,
dispose
in the
of this.
meantime, if I am not getting any interim order, my lord, and the worst part is, my lord,
The court cannot.
my lord, may I just say only one thing? The worst part is, my lord, I've taken, my lord, a report from the structural engineer. The house is built in such a manner that if, my lord, this portion is demolished, my lord, the entire house will come down. That is the reason why, my lord, limited protection, my lord, at least 4 days, 5 days, my lord.
See, this is the national highway project.
My lord.
Correct.
Like this, if this court will interfere all these things, the no project will come. That is the problem.
Only that is the reason.
You know better than me.
Lord,
The parties, what is the mind of the public? They know this is the original, but they will go other. They will keep the original as vacant.
No, over here, my lord, I can at least say, my lord, from the measurements, what is there in the measurements, I am in occupation to that. Not absolutely
with regard
not
to
beyond, my lord.
See, with regard to 66.90 and 109 is was different. Okay, 1 square meter, 2 square meter, 10 square meter could have been considered. But 66.90 and 190.
My lord, may I just say this, my lord?
Conversion.
May I just say this, my lord? Over here, the joint inspection report doesn't, my lord, specify the details, my lord, of the calculation. It only refers to the sketch map. Now, the sketch map, if your lordship sees, my lord, if a reason has to be there, there has to be the reason must be specific, my lord. That is, my lord, what I'm trying to impress upon your lordship. My lord, only their measurements are given. The measurement itself is, my lord, absolutely contrary to the original map.
Given the front portion, they have given the front portion.
Yes, the front portion is, my lord.
Okay.
My lord, kindly gives me, my lord, some.
My lord, in that, my lord.
I will go before the civil court, my lord, and agitate this.
Sorry. The petitioner has filed the present date application praying for quashing and setting aside the impugn notice dated 15th of June 2023 issued by the National Highway Authority by directing the petitioner to vacate the excess area illegally occupied by the petitioner. Full stop. This court, by an order dated 12th of June 2026, directed the district magistrate Howrah to conduct a fresh inquiry by demarcating the RS plot number 109 by taking into consideration of the original map available with the authorities in presence of the petitioner within a period of 10 days from date and to submit the report before this court on 23rd of June 2026 along with a sketch map to show which portion of the land is alleged to have been occupied by the petitioner. In compliance with the order dated 12th of June 2026, the district magistrate, in presence of all the stakeholders, including the petitioner herein, has conducted the demarcation over the property. At the time of demarcation, it was found that HIT wing of the KMD had allotted one khata of land over RS plot number 109, that is 720 square feet, which is equivalent to 66.90 square meter to the writ petitioner for rehabilitation purpose. And on ground measurement, it appears that the present petitioner is possessing the excess of 190 square feet of the land unauthorizedly, along with the allotted area of 720 square feet. 720 square feet. Learned Counsel for the respondent authority submit that this is a national project for construction of the national highway. And when the authorities have found that the petitioner is in an illegal occupation of the portion, accordingly, the inspection was carried out and found that the petitioner is in illegal occupation of the premises in question, of the land in question, and the notice has been issued. The petitioner had disputed the said report of the petitioner has reported the said report of the authority, and accordingly this court specifically directed the district magistrate for conducting the inquiry. From the inquiry report, it is found that the petitioner is in excess land of 190 square feet unauthorizedly, along with this allotted area of 720 square feet. Thus, this court finds that there is nothing to decide in the writ application. Accordingly, the writ petition is dismissed.
Grateful to your lord.
They take the original matter.
My lord, may I get back?
Your lordship,
Go today. You go and file it. Today you
5 days, my lord, for taking steps, my lord.
No.
Because they have also issued
If
another.
it's not a national project, it could have been a private dispute. I could have been granted.
I'm grateful to
This is the national project. Which is sorry. Come with a private dispute, we'll see.
I'm grateful to your lordship.
Grateful, man. Next.
Grateful.
Yes.
The Drugs and Cosmetics Act, my lordship, was the other day heard the matter, my lord.
Yes.
Child Benojet, my lord, was the matter which was said whether it will be going through the microbiological test or not. The information slip, my lord, under RTI, my lord, it goes to the way that no microbiological test 220 is the information slip given by the no microbiological test is required. But we draw your lordship's attention with regard to the page 170 onwards, that not legible copies were there. Lordship permitted us to use the legible copies. Page number. This bunch, I have given the extra copies, but page 170, 71, 72, 73, all the first 4 pages. Those are the writ petitions, page 170 onwards. My lord, kindly come to this, my lord. This microbiological at the top, my lord, kindly manufactured by and supplied by, left hand side top. This is a test report. Sri Balaji test, my lord, it has no recognition. They have found that there is a microbiological deficiency. Manufactured by, not supplied. Well, it is
where from you reading?
At the top, left hand side, very first page.
Yes.
At the top, submitted by
Uttar Pradesh Medical Supply.
Address, manufactured by, supplied by, not supplied. But this is mandatory. They have to supply. I have got the rules.
Yes.
Batch number, mother, secret code has been imposed. Whether my batch has been tested or not, not been discussed.
Secret code.
Secret code has been used. Mother, kindly come slightly down. 1, 2, 3, 4, 5, 6, 7, 8th item is benzyl benzoate. Kindly mark it, my lord.
Benzyl benzoate, yes.
Immediately, benzyl benzoate contamination in non-sterilized product IP 2022.
Yes.
Now, kindly come to opinion at the bottom. Opinion. In the opinion of the undersigned, the sample referred to above is not standard quality as defined as in the act, and the rules made thereunder for reason given below does not comply the IPWT total acrylic viable count. Kindly look at the regulation. That was the IP. Indian permissive.
Who is for the respondent? You are appearing?
Appearing for the respondent.
But I am appearing through
With the
VC.
senior counsel.
Copy kothay? Cutaneous, kindly come to table C.
Yes.
The product is for cutaneous.
Yes.
Cutaneous use. No specific. Not will get it, my lord, immediately down the bottom, my lord, table number 6. In the middle, table number 6. Routine administration. Routine administration, TAC, TFP specified microorganism. But so far as the other items are concerned, so far as the cutaneous use, that is my product, nothing has been indicated whether this microbiological test is to be done.
Yes.
Now this laboratory, page 220, once again, I draw your lordship's attention to page 220 of the writ petition, where the information slip goes to show no microbiological test is needed. Page 220.
Yes.
And I have been discarded on the ground of negative remark with regard to the microbiological test only. From 2022 onwards, I am supplying this item. My item was accepted. 22, 23, 24, I got payment. No difficulty. I had a test report. I have given the test report according to the regulation. All on a 25 supply, my lord, they withheld my payment. That goes over 1 crore. When I insist for the disbursement of payment, which according to the regulation, within 45 days I am to get it, they denied the said payment with imposition of penalty and everything and blacklisting me by saying that this is microbiological test report goes against you. But if that was the condition, but that microbiological test report has been taken by whom? The UP authority. They are not the distributor. They are supposed to inform to the
supplied it
in 2025.
To whom you have supplied?
The UP, Uttar Pradesh Medical Supply Corporation Limited.
You are supplied to the Uttar Pradesh Medical Supply.
Yes, and they are
and Uttar Pradesh Medical Supply has sent to the Sri Balaji Medical Test.
Yes, Balaji and other private medical units,
Correct. And
units
yes.
without any license to them.
Correct.
For microbiological test.
Correct.
And this, my lord, our 220 is saying that no microbiological test is required on this.
Yes. Who has issued this?
At page
State Drugs Control Laboratory.
Yes.
Correct. So you are agreed by the decision census and so microbiological contamination
come for one
does not include the microbiological.
Once again, kindly come to page 221 immediately.
Yes, that's why you read now.
Now I am reading the volume 2 of the writ petition.
Yes, I have gone through 221.
221 also has gone as and this issue was never raised in earlier round of and there has been an amendment of ducks and
comments. So this is your contention.
That is my contention.
Yes.
May I respectfully submit, my lord?
Yes.
My lord, I have raised 2 preliminary objections with regard to availability of the arbitration clause and to the territorial jurisdiction. My lord, firstly, with regard to the arbitration clause, my lord, my learned friend have raised a submission that since it is a criminal law and therefore the arbitration will not apply. My lords, my respectful submission is, my lords, may kindly have the impugned order. That is page 32 of the CAM 1, my lords, which they have filed.
32?
Of CAM 1, application whereby they have filed the order.
And the impugned order was not in the writ petition, but subsequently an application was
not in the writ petition.
Order.
It was filed by a CAM, separate CAM.
Yes.
Lords, may kindly have page 32.
Yes.
Lords, the order has been passed only with regard to raising penalty as per the tender condition. Order has been passed.
See, you have raised the imposed penalty because the
Lords,
material.
I will submit on that also.
Yes.
On merits also, I will submit, Lords. But before that, Lords, only with regard to the submission that since it is a criminal law and offences are involved, therefore it cannot be sent to the arbitration. To that, my submission is, my lord, no criminal action we have imposed. We have only imposed the penalties and the blacklisting as per the tender condition for violation of tender condition.
Correct.
Lord, therefore, it is simpliciter a contractual dispute and it should have been raised before the arbitrator.
Where is that this arbitration clause?
Lords, may kindly have page 80 of the writ petition.
Yes.
Lords, page 80, clause 21.
Yes.
Resolution of dispute.
Yes.
If dispute or difference of any kind shall arise between the tender inviting authority, purchaser, and the successful bidder in connection with the with or relating to the contract, the parties shall make every effort to resolve the same amicably by consultation. Thereafter, Lord, if clause 2, if after 30 days from the commencement of such informal negotiation, the purchaser and the supplier has been unable to resolve amicably a contract dispute, either the tender inviting authority or the purchaser or successful bidder may give notice to the other party or of its intention to commence arbitration as provided by the applicable arbitration procedure and shall be as per the arbitration and conciliation dispute. Lords, may kindly have clause 1. If dispute or difference of any kind,
yes,
if they were aggrieved that my contract penalty has been wrongly imposed, this microbial testing was not required at all. That could have always been raised before the arbitrator. Nobody stops them. We are not saying that we have imposed you a prosecution so that it cannot be. Thereafter, my lords, one more subject was there, my lords, with regard to the territorial jurisdiction. On that date, my lords have seen certain documents with regard to territorial jurisdiction. My lords may kindly have the letter of intent.
Yes.
Which has been issued to them. Lords, what I am trying to convey by showing letter of intent at page 120.
Yes.
You are required to send duly signed and stamped copy of the letter of intent along with the original agreement as a token of your acceptance to this office.
Yes.
My lords, my respectful submission is that my lords, it is settled principle of law that the contract is concluded only when it is signed by both the parties. They were required to send the copy duly signed and stamped by them. When it reached to the Lucknow office and it was signed by the, my lords may kindly have the contract also. Page 124 would be relevant.
Yes.
My lord, this has been signed by them at their office, but it has not been signed by the purchaser. Page 124, my lord, fine.
Yes.
It has not been signed by the purchaser.
Correct.
It was signed only when it was received in the UP office and then the competent authority has signed it.
Correct.
Then, my lords, may kindly have the next page, which is the bank guarantee.
Yes.
Page 125, my lord. That is the bank guarantee.
Yes.
My lords may find at the top itself, this bank guarantee was issued in favor of UPMSCL Suda Bhavan, so and so, Sector 7, Lucknow, Uttar Pradesh. Therefore, in any event, if this bank guarantee was to be executed,
No, the bank, where the bank guarantee was open, which bank?
my lord, it was opened at Kolkata.
Then
My lord, it was issued in our favor.
the cause of action is settled law. If any part of cause of action arose of any where the cause of action may
Lord,
be cause of action.
Then may I respectfully submit,
You
Lord?
admitted that the agreement, the petitioner has executed his agreement at Kolkata, and the performance
Petitioner has only signed, my lord.
the performance guarantee was submitted in the Kolkata bank. So part cause of action already arose in Kolkata.
Yes. Lord, may I respectfully submit? The contract was, what I have submitted is that the contract was finally concluded in UP because it was signed by the authority lastly in UP, only then it became a contract.
Okay.
Thereafter, my lords, the products which are in question, they were supplied in UP.
Okay.
They may have been manufactured at Calcutta.
From where?
That was I am submitting, Lord. They may have been manufactured at Kolkata, but they were supplied at UP. They were used at UP.
Yes.
Notice was issued from UP.
Correct.
Hearing was conducted at UP. Order was passed at UP.
Correct.
Merely we have served the order to them at their registered office will not give the cause of action because actual cause of action arose at UP.
Yes.
Now coming to the merits, my lords.
Yes.
Now, lords, coming to the merits.
Correct.
Lords, may kindly have page 69 of the contract. Lord, this provides page 69, 69, my lord.
Yes.
Lord's clause 2 mentioned here is standard.
Yes.
The drug supplied under this contract shall confirm the standard prescribed in the technical specification mentioned in
where from your reading? Page 69.
At page 69 at the bottom.
Standard. Yes.
Standard.
Yes.
The drug supplied under the contract shall confirm the standard prescribed in the technical specification mentioned in Annexure A and shall conform to the standard laid down in Drug and Cosmetic Acts and Rules 1945. Thereunder, not currently in force. For the drug which are not in official IP, currently in force in the country, then it shall conform to the standard of other pharmacopoeia currently in force as per the provisions of Drug and Cosmetic Rules thereunder.
Yes.
Now, may kindly have section 16 of the Drug and Cosmetics Act, which I have quoted in my counter affidavit, Lord. May kindly have page 8 and paragraph 21 of my reply, Lord. Objection, I'm sorry.
Para
21.
Yes.
Lord, I have quoted section 16 and then rule 124.
Yes.
For the purpose of this chapter, the expression standard quality mean in relation to the drug that the drug complies with the standards set out in the second schedule. We are concerned with this only. Lord, the second schedule specifies that drugs included in Indian pharmacopoeia should comply with the conditions of Indian pharmacopoeia as provided. Lord, thereafter I have quoted rule 124.
In relation to a drug, the drug complies with the standards set out.
Set out in the second schedule.
Where is the
If
second
Malord
schedule?
if Malord want to see that second schedule, Malord, I
Yes.
will mention.
Where's the second schedule?
Malord, the second schedule must be in the drug and cosmetic book, Malord.
A drug and cosmetic rule আছে কি? Book আছে? না, কি আছে? কিছু নাই।
Malord, rule 124 will further clarify it.
Just a minute.
Malord.
Yes. Schedule, second schedule.
Second schedule, Malord. Malord, it might be page 55.
First schedule. Second schedule, yes.
Second schedule, entry 5 may be seen, Malord. Drugs included in Indian pharmacopoeia.
Yes.
Not thereafter corresponding entries, standard, identity, purity, strength is specified in the edition of Indian pharmacopoeia for the time being enforced and such other standard as may be prescribed.
Yes.
Thereafter, Lords may kindly see rule 124. I have quoted in para 21, Lords.
One 124.
Rule 124 at page 8 itself, Lords.
Yes, yes, yes.
Standard of drug.
Yes.
For the drug included in the Indian pharmacopoeia.
Yes.
Then clause 1 says, Lords, the standard for identity, purity, and strength shall be those as may be specified in the edition of Indian pharmacopoeia for the time being enforced.
Yes.
Lord, therefore, my lord, substantially we can say that for a drug to be which is included under Indian pharmacopoeia has to comply with the conditions of Indian pharmacopoeia.
Correct.
Now, my lords may kindly have CA2 because it has been argued that the drug in question does not require any microbial test because the table does not show any number or quantity of microbial element in front of that particular use.
Correct.
In order to clarify, we have clarified the position from the Indian Pharmacopoeia Society itself. Lords may kindly have page 42, CA2 of my objection.
Yes.
Lord, this is the email written by my lords, Secretary cum Scientific Director, Indian Pharmacopoeia Commission. At the bottom, my lords may kindly see the name of the authority writing it.
Uttar Pradesh Medical Supply Corporation, Government of Uttar Pradesh.
My lord, this has been sent to the general man. My lord, may kindly having page CA2.
Yes.
It's an email. It's an email.
Page 42.
Yes, my lord.
Yeah.
It's an email by Secretary cum Scientific Director. My lord, the earlier page which my lord was seeing. At the bottom, my lord. It is the Secretary cum Scientific Director.
Yes.
My lord, find it?
Yes, yes.
Indian Pharmacopoeia Commission.
Yes.
This is the society which publishes the Indian Pharmacopoeia.
Yes.
Lords, they have written to us, request for, Lords may now come to the top of the page.
Yes.
to the General Manager, Quality Control, Uttar Pradesh Medical Supplies Corporation, Government of Uttar Pradesh, request for clarification on microbial limit test requirement for benzyl benzoate application. This is with reference to your email dated 27/3/2026 on the subject cited above. It is informed that Indian Pharmacopoeia serves the official book of standard of drug in accordance with the Drug and Cosmetic Act 1940. As benzyl benzoate is intended for cutaneous use, you are requested to refer General Chapter 2.2.9 Microbial Contamination of Non-Sterile Products. Refer page 56 of IP 2026 under Table 6, Acceptance Criteria for Microbial Quality of Non-Sterile Doses. The applicable limits for cutaneous use are as follows. Thereafter, my lords, last May, accordingly, the above limit shall be applicable to benzyl benzoate preparation intended for cutaneous use. My lords,
Yeah.
therefore, it is clear that microbial testing was required and the acceptable limits have also been clarified. Therefore, this contention that no microbial testing was required at all is not sustainable, because the Indian Pharmacopoeia, which has issued the Pharmacopoeia itself, is saying that yes, microbial testing is required and the required quantities are like this. Lord, we have annexed the relevant part of the microbial IP also, my lords. My lords, it may be page 43, my lords.
Yes.
We have annexed the relevant portion also.
Yes.
Acceptance criteria for microbial quality of non-sterile pharmaceutical substance and non-sterile dosage form. They have specifically specified that microbial testing is required for non-sterile drugs also. Therefore, their submission that microbial testing was not at all required is unsustainable. Now, the second submission is that since in the table 6, note the table below, table 6, no microbial quantity is mentioned, therefore the drug is not required. That clause is also removed by the email by the society. That 10 to the power of 2 and 10 to the power of 4, that would be required for cutaneous use and the drug in particular also.
No, that's why they are relied upon the same table 6 acceptance criteria for microbiological quality of non-sterilized process from. Correct. So in this kindly come
cutaneous
to
use.
Yes, cutaneous. It is nothing mentioned in the neither TSC nor the TFC.
Yes.
So what is the answer in the, why for table 6?
My lords, they have clarified this by the email. This quantity itself would be required for benzyl benzoate intended for cutaneous use. Lords, may kindly have page 41.
Once in the book, what is what is this? What you are telling this? What is the
Indian Pharmacopoeia, my lord?
No, this is in the microbial contamination in the non-sterile product. What is this? This is a book or what is this?
This is, my lord, this is a book. This is a book, my lord. This is a book published by this society prescribing standards of the drug.
If the book published this, so how it can be contrary to this book? The report can be contrary to this.
My lord, may kindly appreciate this. This has also been pleaded by the petitioner that cutaneous use is a genus.
Correct.
And I'm sorry, sterile use is a genus and the cutaneous use is a, Lord, what I say is a smaller ring in that. So this, Lord, 10.2 and 10.1, which has been written, will also cover the other uses also.
No, once that's
that has been clarified by them.
Then what is your answer to this report up to come to the page 221 of the writ petition? The State Drugs and Control Research Laboratory stating something else.
Lord, my respectful submission is that anything, if there is a confusion, can always be clarified by the authority which has written it.
Correct. So now that's
Therefore,
why, what is,
therefore,
how you dealt with the 221? How you dealt with the 221?
my lord, in the order itself, my lord, in the
No,
order,
page 221, kindly come to the.
my lord, I have seen that RTI reply.
Yes.
In the order, my lord,
Where is that? So, which paragraph you are dealt with?
No,
Lord, in the order we have dealt with specifically.
not dealt with.
Lord, I am just showing that paragraph where we have dealt it. Lord, may kindly have page 29.
29 of writ petition
Of the CAM application by which they have annexed the order.
Hey, तुम लोग कैसा काटते सब खुल जाता तुम लोग काट देते क्या है ये क्या काटते उसे काट के देते पूरा का पूरा काट देते सब निकल जाता सारा रेट पिटिशन ऐसी है yes
Lord, may I kindly have page 29?
yes
Lord, may we have put it the question in the table. We have placed the question what they have asked. They have specifically asked a question that whether benzyl benzoate is required microbial testing or not. Lord, may I read the question itself?
yes
Whether microbial test is applicable in benzoyl benzoate application, since monograph of Indian Pharmacopoeia 2020 did not prescribe microbial test. Apart from the above, the general chapter of Indian Pharmacopoeia Addendum 2024 did not prescribe any specification of TAC and TFC.
correct
And specified organism for non-sterile doses from having its route of administration of cutaneous use. It is pertinent to note that benzyl benzoate IP is for cutaneous use. Photocopy of the respective pages are as annexed. Then the answer, my lords, would be relevant. The test parameters of benzoyl benzoate application IP as per Indian Pharmacopoeia 2022. Monograph of the general chapter of IP 2022, namely microbial contamination of non-sterile product, does not include any microbial test. What they are replying is, what the drug officer is replying is that monograph and general chapter of IP, namely microbial contamination of sterile products, does not include any microbial test.
correct
That is perfectly contrary to the chapter itself.
no what is your demand where is your contract what is your demand
My demand is that the drug should confirm
where is the tender and where is that this specific
Page 85 kindly come. I can assist you lordship for that.
Serial number 39.
Serial number 39, what they demanded.
Which page, sir?
page 85 annexer A
Annexer A. Annexer A, that is the last, entry 39, my lord.
yes page 85 of the writ petition
Yes, page 35 of the writ petition.
Entry
Entry 39.
huh?
Entry 39, my lord.
yes 39
At the bottom.
Correct.
Benzyl benzoate application.
correct
What the petitioner has claimed, lord, since IP is not written here,
correct
therefore they are exempt from complying with the conditions provided under Indian Pharmacopoeia.
correct
My lord, that can never be a, my lord,
no that's why the contract you have to deal with the contract what you have asked for
yes.
correct
Indeed,
if
my lord. Indeed.
it's for a quality and quantity of this grade then you have to accept this grade you have taken and subsequently you cannot that's why you tell me how this 39 can be taken into consideration of your reply
My My lords, my respectful submission is that IP is only.
Now come to your page 41, the reply
Yes,
which
sir.
you are relying upon, the report which you rely upon.
Page 41 of my
41
report.
affidavit,
Yes,
yes.
yes, my lord. Email, that email. Yes, yes.
Correct.
Yes.
So now you come to this and come to this tender and the report, RTI report and your report.
My lord, I will respectfully submit. My lords, may kindly read the last line of at page 41.
Yes.
Accordingly,
Hmm.
accordingly, the above limit shall applicable to benzyl benzoate preparation. They are
Correct.
not writing IP.
That's why. But what you have asked for page 30, that's why I'm telling page 85, item number 39 is to be
IP
read.
is not written.
Is to be read with page
Yes.
41 of your report and 221 of the petitioner's report.
Yes, yes, Lord.
Correct.
Petitioner's report is
39 is simply vinyl benzoate application 25%.
Yes.
There's nothing IP, nothing.
Nothing.
Correct. Now, you are relying upon accordingly the above limit shall be applicable to the benzene so preparation.
Benzoate preparation.
Then
all the drugs of benzoate preparation, whether it is 25 ml, whether it is more quantity, more saturation, that would require to meet out the aforesaid criteria. Because IP is only referring to Indian pharmacopoeia.
Okay.
My lords, I was replying to 241.
Yes.
I'm sorry, my lords, 221.
Yes.
Lords, what the drug authorities are replying is, they have very cleverly replied is, Lord, they have not replied anything about Lord, this particular drug. They have stated that microbial.
Okay. Then I am sending it to the report from the independent agency.
Lords may kindly do it. Lords may kindly do it. One thing more, my lords. It has been said that the report and sample taken were not in accordance with law. My respectful submission is that the Act has been amended in the year 2019 and a new table and a new form has been added, whereby the procurement agencies can get a testing of that particular product. We were authorized.
You cannot, that I am not on that, but the testing which has been done, that testing has to be matched with the product number, serial number.
My lords, may I respectfully submit
how you can say there is a secret? Because if a person has supplied a material to you, a particular material, as like, so that means a batch number, date, correct. So where is the report which you are telling that the
to that NS word has been linked for why it has been done? Because we have taken sample from different batches. And in order to maintain the secrecy, we have just placed a label so that the batch numbers may not be revealed.
Why? So where is you maintain your secrecy, but the other party should know which batch number has been sent. That is the only
other party
to identify the items or not.
The other party very well know. May not the other party very well know that from which batch, which test report. Lords may kindly have the order at page 11. 11 of my objection. My lords may kindly have the table. We have specifically mentioned the manufacturing date, the expiry date, the batch number, from which test lab it has been tested, when the report came.
Where from you are reading?
Lord, I am reading an excerpt, CAM 1.
CAN 1.
CAN 1.
Yes.
Whereby they have annexed the order.
Yes.
And page number, internal page number 2 and page number 11 of the order. Lord, page number 11 of the CAM.
Correct.
Lord, this table, we have given them earlier also. It specifically provides them the manufacturing date, the batch number.
That is not. Where is the report? Where is the report?
My lords, along with the show cause notice, they have been provided each and every lab report whereby which drug was found. In this table also, we have mentioned the laboratory, test report date, and what quantity was found suitable and what quantity was not found suitable.
Correct.
My lords, they have never been placed into dark. They have been given every opportunity. What they are pleading is that microbial testing is not at all required.
No, no, sir, I am asking a simple question. I am not that it is. So, okay, this is the batch number you have mentioned, the name of the lab you have mentioned, date of the report is mentioned.
Report number has also been mentioned.
Come to the report. Where is the report? Which page?
My lord, report has been annexed by the petitioner from page 170 onwards, my lord. Few reports have been mentioned, my lord, only.
Yes, kindly come to the report.
My lord.
Correct. The first Balaji test report. Balaji test lab report, private limited.
My lord.
Page number 71. That is which page number? This
page number 170, my lord.
71.
Yes.
171. Kindly come.
170, 171, all have been given.
Kindly come.
Not 170.
Yes. So this is a Balaji test lab.
My lord.
Correct. Now the Uttar Pradesh, there is no problem. Manufactured by NS, supplied by NS, and batch number, secret code number. So who has given the secret code, and whether how you can compare that secret code, this is along with the batch number which you are given in the
Lord,
report.
that is our internal record, my lord. We have all the details.
But the court has to satisfy. But this is where is the, that's why you show the total verification. Yes,
Lord, I will file. Lord, I will file each and every detail with regard to that secret code and batch number.
Yes. How the secret code has come?
Lord, that also I will explain, and I will file the relevant records related to that also.
Because the secret code, you have given the secret code, code, and you are giving the batch number. How the batch number, this report can be treated is consonance with the
number. Lord, I will explain that also. I will file the origin. If my lord want to see, I will present the original records also.
I don't want the original record, but you have to satisfy with reads because see, you are relying upon this test report. You have issued the SOCAS and you have passed the impugn order.
Yes.
Correct. Now, with regard to the whether the report is correct, but the batch number, the same report, whether how you can corroborate that?
I will satisfy each and everything. I will file the records related to that also.
And these test laboratories have no license. Let them satisfy your lot.
I will file the license also.
Microbiological test.
Yes, and
I will file the license also. This statement should not be made in such a.
Yes, it is done.
The matter, Learned Counsel for the parties have argued the matter at length, but full stop. The petitioner has raised the issue that the test report which the respondents have relied upon, in the test report, the name of the manufacturer has been recorded as NS, supplied by NS capital, batch number, secret code number not mentioned, and secret code number
secret code mentioned here, my lord.
Secret code number is recorded as DUPMSC X125001551 full stop. The petition, the London Council, the respondent prays for time to file supplementary affidavit to corroborate that how the secret number is recorded in the report issued by the laboratory. Let the supplementary affidavit be filed by disclosing the corroborative secret number and the manufacturer number and and the serial number of the product as well as the license issued by the authority to the said lab. Let the supplementary affidavit be filed within 2 weeks. 2 weeks, full stop. The reply, if any, there to be filed within a week thereafter. List the matter, give the date.
My only prayer is this, man, that 26 batches are in dispute. So far, the rest of the batches, which are not subject matter of dispute, let by payment be released for that. They are utilized the same.
Let they come.
They have utilized the same, ballot. Kindly, man, at least some equitable relief be granted in favor of the petition.
No, no. 4 week कहाँ आएगा 14 जुलाई में? अगस्त में देखो ना डेट.
Well, undisputed payment be released. I cannot survive. My companies are absolutely
6th August 22 at 2 p.m. 12 noon.
Well, this is small
Yes,
scale
next.
industry,
Call the
my admitted dues will not prevent them.
Mister, it is final hearing is going on.
No, that is for 26 batches. Other batches are not subject matter.
Made a representation, request to
We have given a representation.
Okay.
The
Next,
pendency of the matter will not, at least make the liberty to us, my lord. Pendency will not prevent them from making the payment in respect to undisputed area.
Come next. Yes, next.
Okay. The lordship recalls is mine.
Solo.
The issue was non-consideration of the petitioner's application under the framework for revival and rehabilitation of micro, small and medium enterprises.
Yes.
Your lordship would recall I had made a submission that insofar as banks
Which
are
was the
concerned-
respondent? Yes, what is the
I'm for the 4, 5 and 19.
May I just make one submission, less than 1 minute, your lordship. My principal submission was that insofar as banks are concerned, there is no controversy. Pronates Samat Construction completely settles the issue. A new issue has been raised that the 2016, the March 17, 2016 RBI circular is not applicable on NBFCs and other entities apart from scheduled commercial banks, because that is addressed only to scheduled commercial banks. To that, my response was 2016 circular is separate and distinct from 2015 notification. I had shown section 9 of MSME Act, read with 29(3) of MSME Act, and said that and submitted that this is a delegated legislation. In its operation to scheduled commercial banks, which is governed by RBI, they had made certain revisions in view of inconsistency with IRAC notification. That does not curtail the operation, that does not restrict the operation of the original 15. I had also quoted Samarth Construction, where cooperative bank was concerned.
Yes. What is the answer?
One issue.
What is the answer? Sir, every day I cannot recapitulate. I will not waste the time. Yes, what is your answer?
My lord, if your lordship kindly takes up section 10 of the MSME Act once.
आप लोग कुछ नहीं रखते, रोज हियरिंग होता.
Lord, may I be allowed to?
ना शाम को चैम्बर में आएंगे, हम आपको फोन करके चैम्बर में बुलाना. आपसे एक इनविटेशन कार्ड रखूंगा.
MSME Act now.
If your lordship kindly takes up section 10 once. So, my lord, in the instant writ petition, my lord, MSME Act. In the instant writ petition, my lord, they have prayed for availing benefit of notification of 2015. Now, my lord, before that, how they will get benefit from out of certain credit facility they have obtained, my lord? Now, how will that credit facility will be advanced to the MSME? If your lordship kindly, may I be allowed to read it out, my lord?
Yes.
Section 10, the policies and practices in respect of credit to the micro, small and medium enterprises shall be progressive and such as may be specified in the guidelines or instruction issued by the Reserve Bank from time to time to ensure timely and smooth flow of credit to such enterprises, minimize the incidence of sickness among and enhance the competitiveness of such enterprises. So, my lord, the credit facility which will be granted or provided to the MSME, that will be in terms of RBI guideline. Now, my lord, may I be allowed to hand up
guidelines of RBI so far MSMEs are concerned.
You are appearing for Axis.
I am appearing for, my lord, Axis Finance Limited, which is a NBFC, Axis Bank Limited, and Yes Bank Limited. My lord, I have two-folded submission. So far NBFC is concerned, and so far bank is concerned.
Yes.
If your lordship yes, ma'am. If your lordship kindly comes at first page of the master direction, this is lending to micro, small, and medium enterprises MSME sector. So my lord, section 10 says that the credit facilities will be in terms of the guidelines issued by the RBI. Now, my lord, this is the last updated guideline, as your lordship can see from the date. Actually, this is of July 24, 2017, which was updated lastly on February 9, 2026. Now, my lord, kindly comes second page.
February 9, 2026. Where you got this?
My lord, at the top second line.
Okay.
Circular is of July 24, 2017. It was updated lastly on February 9, 26.
Yes, yes.
Now, my lord, in exercise of the powers conferred by Section 21 and 35A of the Banking Regulation Act 1949, the Reserve Bank of India, being satisfied that it is necessary and expedient in the public interest to do so, hereby issues directions hereinafter specified. Now, my lord, where this master direction will be applicable? This direction shall be called the Reserve Bank of India lending to micro, small, and medium enterprises direction 2017. This direction, thereafter the updation, my lord. Now, my lord, kindly comes to 1.2, the applicability. The provisions of these directions shall also apply to all scheduled commercial banks, excluding regional rural banks, RRBs. So far the granting of credit facilities are concerned, that has to be in consonance with the guidelines issued by the RBI. Now, once RBI issues the guideline, that RBI made it applicable only for the scheduled commercial banks. Now, my lord, thereafter, definitions are concerned. My lord, kindly comes next page, chapter 2. My lord, kindly comes to 2.4, clause 2.4. There are certain definitions, my lord.
Yes.
The certificate issued on Udyam Assist portal to informal micro enterprises shall be treated at par with Udyam registration certificate for the purpose of availing priority sector lending benefits. IMEs with an Udyam Assist certificate shall be treated as micro enterprises for the purpose of PSL classification. But MSME concerns were always a favored child of our government of India. So, to motivate and to make them grow, they have made various guidelines on various occasions in terms of Section 9. Now, so far this credit finance is concerned, my lord, they have made priority sector lending credit facility. Now, then chapter 3. Priority sector guidelines for MSME sector. Very specific, my lord. Scheduled commercial banks shall adhere to the targets and sub-targets for lending to the MSME sector and related aspects as laid down in the master direction shown. So, my lord, I am carrying it. Should I hand it, my lord? Yes. আচ্ছা, আমাকে দুটি কপি আছে, পড়ে আমি দিচ্ছি।
Yes.
Now kindly comes to page 2, chapter 2.
Yes.
My lord will find categories under priority sector. So my lord, here number 2 is the micro, small and medium enterprise. So my lord, whatever credit facilities in the nature of micro, small in the guideline of RBI, that is treated as a priority sector loan which is being given to the MSMEs. And my lord, so far this is concerned, this is also towards the banks.
Yes.
Now, my lord, kindly comes to next page of the earlier master direction, my lord.
Yes.
Kindly comes to, there are certain, why I have submitted favored child, there are certain benefits which are being given by the banks to these MSMEs. There are certain guidelines. Kindly comes to chapter 4, clause 4. Common guidelines, instruction for lending MSME sector. Banks are mandated not to accept collateral security in case of loans up to 20 lakh extended to units in the MSME sector. Banks are also advised to extend collateral fee loans up to 20 lakh to all units financed under the Prime Minister Employment Generation Program administered by KVIC. So there are certain conditions which are only being given to the MSMEs. So my lord, these credit facilities are curated only for the MSME.
Correct. There's no dispute on that.
Yes, my lord. Why I am referring, because all these directions towards the banks. That is why, my lord, I am taking your lordship to these circulars. Now, my lord, kindly comes to 4.5.
So your main contention is NBFC is not coming under purview of any of the guidelines.
And in the notification, I'll show. Kindly comes to 4.5.
Yes.
Again, my lord, debt restructuring mechanism for MSMEs.
Yes.
All commercial banks are advised in terms of our circular date so and so of 2009, my lord, first it was of 2009, to do the following. Put in place loan policies governing extension of credit facilities. So, my lord, again, my lord, I am submitting that since the MSMEs are treated as favored child of Union of India, so my lord, they have their certain conditions for these MSMEs. Restructuring rehabilitation policy for revival of potentially viable sick units, enterprises now read with guidelines on framework for revival and rehabilitation of micro, small, medium enterprise issued on March 17, 2016. So, my lord, notification is of 2015. Now they are referring that it will be of 2016. Why, my lord? I will show that. Again, my lord, kindly comes to clause 4.6. Framework for revival and rehabilitation of MSMEs. The Ministry of MSME, Government of India, via their Gazette notification dated May 29, 2015, had notified a framework for revival and rehabilitation of micro, small and medium enterprises to provide a simpler and faster mechanism to address the stress in the accounts of MSMEs and to facilitate the promotion and development of MSMEs. After carrying out certain changes in the captioned framework in consultation with the Government of India, Ministry of MSME, so as to make it compatible with the existing regulatory guideline on income recognition, asset classification and provisioning pertaining to the advances issued to banks by RBI. This is very important. Issued only to the bank.
Yes.
The guidelines on the caption framework along with operating instruction were issued to bank on March 17, 2016. The revival and rehabilitation of MSME units having loan limits up to 25 crore would be undertaken under this framework. But then, my lord, it is very important as for me, my lord. the revised framework supersedes all earlier guidelines, rehabilitation of sick micro small enterprise by our circular date so and so. Now, my lord, why I am showing this master direction, that the credit facility granted in favor of the MSMEs has to be in terms of guideline of RBI. Now, lastly, my lord, RBI issued a master direction to extend credit facility in favor of the MSME. So, our credit facility has to be in the nature of priority sector lending. So, it is not a general lending. This has to be a priority sector lending when you are taking benefit of this notification. Now, when it kindly comes to now, the notification of 2015. Page ta bolo to. Page 653. Volume
63.
Volume 5, page 653. Volume 5 ta deben. And another thing, there are certain up to 20 lakhs, it will be collateral fee. So I can, with my little knowledge, I can term it secured credit or unsecured credit.
Yes, 663.
My lord, 653, volume 5.
Yes.
This is the notification of Government of India.
Yes.
My lord, I am not bothering with, because my learned friend has already shown to your lordship the identification portion which my learned friend has shown.
By the banks or creditors?
Yes, bank or creditors. And why I am mentioning that it is credit facility can be secured, unsecured. So bank may be secured creditor or unsecured creditor. Since priority sector loans are of two types. One is unsecured, one is secured. So far bank is concerned, bank may be termed as secured or unsecured. So bank, it is a creditor. That is why, my lord, it is bank or creditor, not bank and creditor.
Bank or creditor?
Bank or creditor. My lord, it is not bank and creditor.
So what do you mean to see the creditors?
So far, surface action is concerned, we have seen secured creditor. So, my lord, why secured creditor? Secured creditor includes banks and as well as other financial institutions.
Yes, correct.
My lord, so far, this notification is concerned, creditor means bank is a creditor. It may be unsecured creditor, it may be secured creditor. So far, my understanding, my lord. So far, my understanding. I am trying to convince your lordship, my lord. And I'll come up with the judgment, then only I'll show.
Yes.
Then, my lord, kindly comes to committees for stress, clause 2.
Yes.
Point 2. Committees for stressed micro, small and medium enterprises.
Yes.
Subject to any regulations prescribed by the Reserve Bank of India for this framework. So, my lord, this framework will be executed by RBI by its own regulations. Or, my lord, it is the notification, my lord. I am reading from the notification.
Correct.
All banks, my lord, here it is clear. All banks shall constitute one or more committees at such locations as may be considered necessary by the board of directors of such bank to provide reasonable access to all eligible MSME enterprises which have avail of credit facilities from such bank. So there is no mentioning of any other creditor or financial institution, no, only bank. Then, my lord, 2, subject to inclusion in categories referred to in paragraph 1, stressed micro, small and medium enterprises shall have access to the committee for stressed micro, small, medium enterprises for deciding on a corrective action plan and determining the terms thereof in accordance with the regulations prescribed in this framework.
Yes.
Provided that where the committee decides the recovery is to be made as part of the corrective action plan, the manner and method of recovery shall be in accordance with existing policies approved by the board of directors of the bank, which has extended credit facility to the enterprise subject to any regulation prescribed by Reserve Bank of India. So, my lord, only so far those loans.
So your question, your answer, your submission is that everywhere it is mentioned as a bank, it is not mentioned in
Even, my lord, member of the boards are all from banks, other
Correct.
than a state government representative. Now, my lord, this is very important. If your lordship kindly comes, but I am not disputing that they have not mentioned creditors. So far, my understanding goes, all of the creditors.
So see, that's why that is to be decided only after exchange of affidavits on merit. Correct. Now he is on the interim stage. So what is the answer to the interim relief?
My lord, so far NBFC is concerned.
Because whether the NBFC is covered under the notification or not, that is the subject matter of the writ application.
So far, my submission, my lord, so far NBFCs are concerned. If they are not covered under this notification, they cannot get benefit under this provision.
Correct. That's why. So it is the interim. If suppose not, then you can take appropriate steps in accordance with law. But if this court find that no, the NBFC is also covered under the notification, then you have to govern by this also. So what at this stage? Let the for the time being, let the matter be decided. Let the matter be decided.
Then, my lord, I cannot enforce my right to, because, my lord, since they are enjoying the money without paying.
See the other side. See the other side. If tomorrow, okay, the court this I am not satisfied that you are not under this notification, and the court cannot invoke directing you to the MSME is not coming under that, and you are the NBFC, and you can take appropriate steps in accordance with your rules and regulations.
And, my lord, there are certain master directions of RBI where they can approach to the NBFC to get certain relief
benefit
before declaring that account stressed. There are IDAC.
Now that's why. So if that, unless if tomorrow suppose the court held that no, the NBFC is also entitled to have the benefit of the notification, then what will happen if you taken these steps?
So far, I am concerned. They are enjoying the money without paying, and they are after defaulting.
So it can be decided as how soon you file the affidavit.
Well, I'll take only.
How many banks are there?
There are in total 19 respondents.
And my lord, for banks are concerned, here, my lord, they have availed general loan instead of prioritized loan. So even then, bank is not obligated. Because, my lord, I have shown that if they avail the priority sector lending, they will get benefit of this notification.
Yes.
But if they avail a general loan, then they are not entitled for that. So even for the bank, my submission is that for the purpose of general loan, banks is
it is not under the MSME.
So far, Axis Bank and Yes Bank is concerned, they have availed general loan. That I can show from
It's not declared in the at the time of loan that is the MSME and
so far document is saying that it is a general loan. It is not a priority sector lending.
If it is MSME, there is a provisions of other. The bank has to take all the recourses.
MSME has to apply for loan under priority sector lending.
Correct. That's I'm telling. So in the form itself, whether it is
it is there, but they have accepted the sanction letter, which says that it's a general loan.
It's a business loan, it says.
It's not a priority sector.
May I respond to that contention? I'll just take 1 minute. Your lordship, kindly come to
what are the other banks?
Lordship, on the last occasion, in the writ petition, my lord, it is stated that the loan has not been recalled. I have taken instructions, my lord. In this case, opportunities were given for one-time settlement, my lord, which had failed. Loan has been recalled and an arbitration has already commenced, your lordship. And also, I would like to take your lordship to this notification that they are relying upon. There is an eligibility criteria, my lord. And according to my client, I've taken instruction, my lord, they fall within the criteria of willful defaulter, which cannot be eligible for restructuring, your lordship. So I would also like to file an affidavit, short affidavit, my lord, within a short
That's why
period of
that all the things is to be brought up.
Insofar as HDFC is concerned, Your Lordship, insofar as HDFC is concerned, on the last occasion, my learned friend had made a submission that no coercive steps will be taken, but they are taking coercive steps. They have put up the vehicle for sale now.
Document I have handed.
Let them recall it. Let them recall it. Let them recall it. And the possession of the first vehicle was taken around 17th and 18th of June, one day before the writ petition was taken up for hearing.
My lord, I have handed up on RTI was utilized by RTI. It is a public document because I have obtained it from the official website of the RTI. So, Lord, kindly transfer second page, answers to the question number 5. Clarification on whether framework is applicable to non-banking financial institution. The framework issued under so and so is not applicable to.
There is a March 17, 2016 circular. RBI comments about, because RBI's jurisdiction is only that.
Earlier notification.
Yes.
Obvious. Yes, this is only the banks from whom he has obtained the loan, and the bank has taken this. That is the argument. That is the law points. Yes.
And may I?
My submission is that if they are not entitled to take benefit of that notification and subsequent that notification must be the subsequent of 2016 minor. If they are not entitled, how can they avail injury protection from the
Now,
may not
by only one submission regarding the credit facility. Much has been said, Your Lordship. I will just very shortly deal. The priority sector, the lending to MSME directions, this is a RBI direction made only to banks, where the banks have a particular obligation insofar as priority sectors are limited, concerned. And the priority sectors include MSME as well as other sectors. So when a bank within the purview of this notification, this direction is lending to one of the priority sector, they have certain obligations. That is the priority sector lending framework applicable to banks. The MSME, the revival and rehabilitation, is a separate benefit to the MSMEs. Now, Your Lordship will kindly take page 654 directly. 654 of volume 5, Your Lordship.
Yeah.
Now, application to committee for corrective action plan, Your Lordship will see any eligible stressed MSME of a bank or a creditor which has provided, the next words are very important, which has provided credit facilities to such enterprise may file an application in the manner prescribed, specified by the bank for a decision for corrective action plan, provided that if an MSME has availed credit facilities more than one bank, so and so. So it is a borrower-based benefit, borrower type-based benefit. It's not a credit facility type-based benefit at all. It says credit facilities. It does not define, it does not confine that it has to be a credit facility of a particular kind. And it's a borrower-based, says any eligible MSME.
Naturally.
Which has provided. So it is not, in my humble submission, it's a borrower type-based benefit under MSME.
That is with regard to the bank, but what about the NBFC?
I'm saying that it is a borrower type-based benefit. A borrower type, as long as I'm an MSME.
Only one NBFC.
No, there are other NBFCs as well.
How NBFC?
There are only 4 banks.
Who?
Cholamandalam.
Cholamandalam.
There are 13 NBFCs.
Judgment of only also only one. Only one.
No, Pronita subsequently the
Samarth Construction.
Yes,
Samarth Construction.
Samarth has extended that benefit that even at the time of 13-3 representation, if the stressed enterprise inform the bank, then also you have to look at.
Correct.
That is the Samarth. And Malat Pronit is the.
Hey, where are the judgments?
समर्थ दिए छो समर्थ का समर्थ
अरे हमारे पास मार्क किया वाला है ना, अब नया नया लाके देने से क्या होएगा? क्या सा कैसा फाइल रखते हैं यार आप लोग, हमको समझ बाकी सब कहाँ है? और एक कहाँ है? और एक होगा, ये गिव द प्रोनी
and
ऑनलाइन का नाम
SCC online, SCC online. We have handed up a true print. True print.
ऑनलाइन वर्जन तो दिए
ना इसे SCC
True print. SCC true print. 2024 10 SCC.
सुप्रीम कोर्ट
True print.
Supreme
2024 वॉल्यूम 10.
Now kindly come to paragraph 18. Why I am submitting to?
Yes.
We start to may happen at essentially at the under framework of revival and rehabilitation of micro, small and medium enterprises. The banks or creditors are required to identify the incipient stress in the account of MSME, put their account down into non-performing assets by creating 3 subcategories under the settlement account category. However, while creating such subcategories, the bank must have some authenticated and verifiable material with them as produced by the concerned MSME to show the loan account is of a MSME.
Correct.
So, that credit facility has to be in the nature of MSME.
That's why, see, the question, what the question arose? Bank has issued the notice, not seen whether it is MSME, they went and the court has stated that, then the court has stated the bank has to see, and even the borrower has to inform the bank as I am under the MSME. In the case, what has happened? They have disclosed the document.
Yes, ma'am.
The bank has taken the plea, in the loan document, there was no MSME certificate. So that's why the court has fixed the guidelines. No, bank has also to be taken, and if anything, that petitioner has also to be brought all the document before the bank, and the bank has to see whether he fulfilled the criteria in terms of the guidelines or not. And subsequently, in the summer, further clarified. Further
The
clarified.
duty of diligence was not only on banks, it is also on the borrowers.
It is saying about
Yes.
So it is the bank, because sometimes banks telling that no, we have no knowledge.
MSME has to be vigilant and it has to bring
So
to its
now
notice.
the borrowers telling that no, I have applied under the borrower and we have submitted the document. That's why the three
it is also mentioning that banks have to have certain authenticated and
verifiable. Before going into the NPA, whatever it is, first they
Right.
have to.
That's correct.
If it is MSME, then the procedure inquiry is to
Yes.
be conducted and all the
Yes,
thing is
yes.
to be done.
So for this case is concerned, if the bank sees that the credit facility granted in favor of the MSME enterprise of my client, that it is not it's a general credit facility granted. So this question doesn't.
Every time new notifications will come and new.
I am relying on the.
Yes, authority.
That is true. But unfortunately, judges are encumbered because of that.
Okay, I will pass on. Very
Yes.
deeply operational. Wait, शाम को हम डिक्टेशन दे देंगे. रखो आज ही ऑर्डर करेगा.
I'm deeply operational.
May I take
Yes, yes. Next.
I am for the petitioner. It was that horizontal vertical PWD matter, my lord, learned advocate.
You are appealing.
I received the notice of my office. Give a notice of it.
Give the inform the whatever the matter, or you give the total documents. Because earlier there was notification, subsequently pendency of the matter, other notification is come. Yes, no problem, no problem, no problem. No problem. No, that's why I directed to issue notice to the, because earlier the AG was appearing. So that's why, I don't know whether this time will appear, issue the notice, whether the AG will appear or it will be engaged some other advocate, whatever it may be. So you go through how. Yes, no problem.
Kindly fix a time, my lord, only.
Yes, I fixed the time. Advocate General raised for time, and though the matter is specific to just 12 noon, but the London Advocate General raised for time, and according case is adjourned. Let the matter give the date. 15th July at 12 noon. 15th July at 12 noon. Come on that day. 15 July. 15 July, 12 noon, please. Yes, next.
But I am for the petitioner in this matter. What happened in this case, my lord? There is the election of the Eastern Railway Men's Union. The election was conducted by the person concerned. They have unanimously decided themselves as an office bearer, those who have retired from service. Now, as per the trade union,
Retired person cannot be a member of the association.
kindly come to page 40. Kindly come to page 46.
Why?
The relief that claimed the repeater cannot be granted in view of the fact that the election process has already been by the annexure P1. The second law is that the process or even the nomination cannot be called in question in the proceeding. The Constitution of the forum otherwise provided under the law. If no such provision are made, the election called in question by way of
correct
and not by way of liquidation. The other thing is claimed by the people holding the state election out of the guidelines by the official authority unless the election already
I am not questioning the election.
cannot be granted. In the view of the association,
In terms of the law applicable in the my learned trainer is giving the copy to your lordship, but he is not giving the copy to me.
Yes, what is a prayer?
Our court also, my lord, identical. Not allow me that.
What is the what is a prayer? What is a prayer?
My prayer,
Page 26. Page
ए,
26.
page 20.
वो क्या जजमेंट रखा हुआ है, फिर आप लोग उसी तरह छोड़ देते हैं इधर उधर
They follow the Trade Unions Act.
रख दो ना फाइल में.
I am only questioning the retired person cannot become an office bearer by violation of the Trade Unions Act.
What is
I
the
have not
prayer?
mentioned the selection process. Can you see? To declare that the election of the private respondent of the post of president, 3 number vice president, working president, and general secretary in the executive committee of the Eastern Railway Congress, those who have retired railway employees is illegal, null and void, ab initio as per the subsection 2 of the section 22 of the trade union. Don't interrupt. You will get a chance.
Yes, yes.
Section 22 of the
So,
Trade
Mr.
Unions Act 1926 for the post of central office bearers only.
Mr. Das, this is a trade union, correct? And the election. So you
Now,
can go to the cancellation office.
I am drawing your lordship at it. There is a connection with the railway because the general manager Eastern Railway has recognized them. Now there is huge budget and accounts also maintaining. They are collecting the money from the railway employee in respect of that.
Correct. The problem is that this is a trade union.
With this judgment. Because of this judgment, I do not know who has
I am not on the judgment. I am overall I am telling this is the trade union. Correct. And the election of the trade union, if with the election of the trade union and if at the time of election it has not taken into consideration of the proper provisions, then you have to go to the conciliation officer before the labor commissioner.
Now, lordship, can you see what is the act says? Particular act says. They cannot violate the statutory act. Because of this fact, my lord, the railway is directly involved in this matter. Can you see the railway letter issued by the chief person?
Yes, naturally, the railway might be.
Because of this fact, man, huge public money they are frustrating in respect of that. The person concerned who are electing themselves, suppose in our ballot season election, there is a secret ballot. No secret ballot, nothing is. They themselves have declared this is a
correct. If you are agreed, then you go under which provision the union is registered.
Trade Unions Act 1926.
Trade Unions Act. Then it will be governed by the labor commissioner.
No, my lord. Kindly see.
How the writ court can go into that?
Can you see the order of the railway?
If you agree with the election, then
I am challenging the order of the railway, page 58. Annexure P9. This is the order of the chief person officer. I am adding in respect of because under Article 12, the writ petition, any writ petition against the government of India is maintainable, my lord. I am challenging this order in my impugned order, page 58. Lordship, can you see? Serial number 1 to 6, all are written. This is after violation of the Trade Unions Act. And they are holding the huge fund, public fund in respect of that. All of the employees' money, my lord. And they are using the facilities from the railway as union office bearers. Now we made a representation before the authority and submitted our grievances. Not a single response they have given in respect of that.
Okay, so now what you want?
I want my grievance may be considered by the railway.
That's why, see, that's why I'm giving a liberty. You go and approach before the appropriate
This is not a
forum.
case of labor. Because today I have seen just now my landed pen has handed over. But I have to produce any subsequent order of the Honorable Appeals Court or Division Bench.
Come. When will you come?
Huh? And not only that, against this order of the railway, the union, this particular bearer, those whose name appear in the working committee's list, they raised a grievance before the railway that why you are recognizing their person concerned
as per the Trade Union Act, they cannot become an office bearers of the union.
Correct. So
Now, they really is not responsive in
that,
respect of that.
if you want, I will give you liberty to file the appropriate application challenging the election and the order, the impugn order before the appropriate forum and the.
No, my lord, I shall overcome in respect of this.
Come.
And kindly, my lord, kindly fix under the same heading.
The
Next, you will have to
Learned Counsel for the Respondent Railway has raised objection with regard to the maintainability of the present application on the ground that the petitioner has challenged the election process of the Eastern Railwaymen's Congress. What is the election of what?
Railway means
Of the office bearers of the Eastern Railwaymen's Congress. ঠিক আছে?
As per the Trade Union Act, my lord, they cannot be retired
Learned
employees.
Counsel for the petitioner, the Learned Counsel for the respondent raised
25,
has relied upon
26.
a unreported judgment in the case of National Railway Mazdoor Union versus Union of India, passed in WP number 6444 of 2014, dated 19th August 2015, wherein which court, which high court,
No, nothing has been done.
Which high court?
Where from the got this order?
wherein the high, which high court,
কিচ্ছু লেখা
wherein the Honorable Madhya Pradesh, wherein the High Court of Madhya Pradesh
তার order
has held that the election petition is not maintainable under 226 of the Constitution of India. Learned Counsel for the petitioner prays for time to take instruction and to reply and to distinguish the judgment relied by the respondent. According case is adjourned, let the matter appear on 3rd July
under the same heading.
under the same heading within 10 matters.
Get.
Next.
And my lord, one line may be recorded that the secret ballot election was held.
If you are raising the mentality, why you further?
Yes.
If you are going to the marriage, then I will hear in now.
As because my
No. I shall come with the judgment.
You are raising a mentality. I have recorded this one. Let's satisfy. Then the ballot or secret or all the thing will come.
Yes. Get more.
Yes, next. Yes, who is for the petitioner?
Yes, my lord.
What is
My
the?
lord, petitioner before your lordship, my lord, is a lady
Yes.
and a senior citizen, my lord.
What's the grievance?
Grievance is that, my lord, she has got 3 daughters and 1 son.
Hmm.
Now, my lord, all three daughters are married, and the son is there, my lord. Son taken the property, entire property from mother, and thereafter driven her out from the home. And now my lord, the ill-fated lady is staying with the daughters 4 months on each and every part of the year, to one daughter and then another daughter and then another daughter. So, my lord, 12 months
Correct.
in a row.
Yes.
Now, my lord, she has complained, my lord, many things before the respondent, your lordship will find, before the SDO, before the police authority, everywhere. But, my lord, most, my lord, ill-fated lady, she has got no remedy, nothing of that.
Have you made an application under section 5 of the Senior Citizens Maintenance Act
My lord,
before
yes,
this
yes,
SDO of
page-
the concerned
page
SDO?
26, no.
Before the concerned SDO?
Page 26, my lord, so it's, you also will find, my lord,
Yes,
and it's P2.
This is, you have to make a proper complaint before the SDM
My lord,
under
thank you.
section 4 or 5.
That is correct. But, my lord, the lady, poor lady, my lord.
See, tomorrow also on this application, if the SDO will pass an order, the other party will come in the writ application. In this application, the SDO will pass an order for maintenance.
My lord, maintenance, I was only seeking, my lord, the grievance which could be redressed by
But
way of.
what is your grievance?
My lord, grievance is that, well, I was driven out from my residential house.
Correct.
And all my money was transferred from my account to his account.
So
The
why you are
money
not
which-
going to the domestic violence?
My lord, that is also there, your lordship. will find.
Which is simple in nature. You persons are not going on that. You are coming in the writ application, filing a 1-page application before the SDO and coming before the High Court. There are so many forms are there.
My lord, what you
Go to the domestic violence. Go to the maintenance. All the things have been provided by the government.
He has only asked for the residential.
Yes, if you not, you go to the legal aid. Legal aid will provide the advocate if she's not able to engage the lawyer. But there are so many things.
They have done nothing. They have done nothing.
Who?
The authority, respondent authority, even after having this,
Carrots, see, authority will consider if there is something in the application. If there will be nothing in the application, kindly go to read the section 5. You have to grievance. You are the owner. Your son. Your son.
Your lordship, may I read for your lordship? May I read?
No problem. I will direct the authority. There will be no problem. Then future you will face the problem. I don't want that. Your client again and again come to the High Court.
Let there be restoration of residential house, my lord.
Restoration, how it can see?
Because she was driven out.
Again, that relief cannot be granted by the SDO.
No,
unless and until you prove that the land belongs to you and you have illegally. So you have to prove all this. The inquiry report has to be brought before the sub-divisional officer, not only with the one application.
Nothing. Even after receiving this, they did nothing.
The only grievance of the petitioner before this court that the petitioner is a senior citizen and 3 daughters, having 3 daughters and 1 son.
Yes.
All the 3 daughters have been married. All the 3 daughters and the son has already married, but the son has grabbed the total land of the petitioner and residential building of the petitioner, and also siphon of the amount of the petitioner.
Yes.
And the petitioner is not having any source of income.
Yes.
It is the further case of the petitioner that the petitioner have made an application before the concerned authority, including the sub-divisional officer for taking appropriate steps, but till date no action has been taken. In view of the submission made by the counsel for the petitioner, the writ petition is disposed of by directing the sub-divisional officer Durgapur, Paschim Bardhaman to consider the application filed by the petitioner dated. That is also not a date. Where is the receipt? Page 30. And you come to page 30.
Your lordship will find at page 28 also.
28, no. Where is the page 30? What is the date of the application?
6th April 2026.
Where?
Annexure P4, page 30.
Where from you? Dated 6th April 2026.
At the top, man.
क्या बोला? Consider and क्या बोला? (6th April 2026) and 21st of April 2025 by giving an opportunity of hearing to the petition and the concerned persons. Dispose of. Opportunity of personal hearing to the petitioner as well as the concerned respondent, and to pass a reasoned and speaking order within a period of 6 weeks from the date of receipt of this order.
Well, great. 6 weeks, well, great.
I'm appearing on behalf of the petitioner.
I like to appear virtually, my lord. I appear for the West Bengal Pollution Control Board in this matter.
Lordship, on last occasion, my lord directed the private respondent to file the affidavit in opposition with all the relevant documents which they have, but till date, we haven't received any affidavit in opposition.
Direction document of municipality to file the document. Only inquiry report, madam. But we have filed today the inquiry report.
Who is appearing for the Pollution Control Board?
I beg to appear for the Pollution Control Board, my lord. I am on the virtual mode.
But you have to pass the order whether it is not your duty to see whether the order has been complied with or not.
My lord kindly takes your lordship's order dated, my lord, 7th of May. And also from the averments of the petitioner, my lord, made in the writ petition, it would be evident, my lord, in terms of the earlier orders passed by the Honorable Court, my lord, we have passed a direction. We have asked the petitioner, my lord, to come before us and submit a compliance report with all the necessary statutory documents, my lord. Till date, my lord, as far as my instruction goes, my lord, no such documents have been supplied by the petitioner. That was my submission on the earlier occasion as well.
What document is required from the petitioner?
My lord, consent to operate and establish is required. My lord. He has to. My lord, if your lordship kindly, my lord, kindly takes page 50 of the writ petition.
Have you read the writ petition? Have you read the writ petition? Have you read the writ petition?
Lordship.
Can you read the prayer?
Issue a writ in the nature of mandamus directing the respondent authorities, including the municipality and the officer in charge of the concerned police station, to strictly comply with the order passed in such and such WPA and to take immediate effective action against the private respondents.
The petition will come to your office for taking action, or you have to take the action. What you are submitting?
My lord, I am appearing for the pollution control board. My lord, kindly takes, my lord.
What is your duty? You have to see whether the all the rules have been complied with or not. You are telling that the petition has not come with the document. Whether the petition will come with the document to you and you will pass an order by sitting in the office, or your officer will go to the site and will inspect whether the street shop is having all the complied with all the rules and regulations.
If your lordship kindly takes page 49 of the writ petition, my lord, there is a record of proceedings. My lord, at page 50, my lord, your lordship would find,
yes,
my lord, upon hearing both the parties, my lord, the board was pleased to, my lord.
You pass the order. This order has been passed. Whether this order has been complied with by the private respondent.
My lord, there is a direction upon the, my lord, the police, the municipality and the regional officer of the board, my lord, to ensure that it is complied with, my lord. But if the lordship.
So whether it has been complied with or not, you have taken the proceeding and passed the direction, your chapter is over.
My lord, if I may, my lord, make this submission, my lord. My lord, if the petitioner, my lord, does not come forward and apply, my lord, he cannot apply, run the unit.
Your officer to come in person. You are not understanding. Petitioner will come, complainant has to come, or the person who has not complied with the order has to come. What you are telling, sir?
My lord, I bow down before your lordship. My lord, may I just please one paragraph of the writ petition, paragraph 13, my lord, at page 9.
Yes, who has filed this report? Yes.
The picture.
No business activities is carried out on so and so. Uttarpara district, municipality, ward number so and so, under the so and so streets of. And the said establishment was under lock and key.
The photograph is
here.
Chairman's report, madam.
No business activities seen. Said address under the name and initial of so and so. Yes. So now what is your submission?
It is
You are for the
private respondent.
8 and 9. Who is the 9?
Owner of the.
Who is the 8? Who is 9? Then who is 9? Why two private respondents?
Two private respondents, lordship. They are the 8 to 10 other problems. They are residing in the same premise.
I am asking who is 8 and who is 9? Why the 9 is there if the 8 is the owner of the shop?
Not owner of the premises is the petitioner. They are the tenants.
Correct. So then who is 9 also? 9 is also
8,
running.
9, 10.
Huh? So they are also running. All three are running.
They are residing there.
All three are running these sweet shops. So why they have been made as a party here? Why the 9 and 10 has been made a party?
They are the accomplices.
Accomplice means they are the shareholder of the business.
No.
Then
they are running. They are helping the respondent number 8 to do all such nuisances. Only for this reason.
So if you say also you are also responsible because you have given the rent on for the sweet shop. without the agreement or without seeing the all the thing, then you are also the accomplice.
Lordship, we are permitted to sell.
If you are telling
a
that the
switch.
8, 9 and 10 is also accomplice, so you are also accomplice because you have provided the shop to the petitioner. Where is the allegation against 9 and 10? Show me the allegation against 9 and 10 in the writ application.
Lordship, I'm coming. Lordship, come.
Where is the description of 9 and 10?
Paragraph number 3, Lordship. Not specifically it is written anywhere.
Respondent number 8 to 10 are the private respondent who got illegal indulgence from the other 2 respondents and committed the actual crime. So all the respondents are amenable. Wow. Good. Good pleading.
Lordship, respondent number 8 is the.
So now there is a report they are not.
Yes, it is evident that they are not.
What do you want? What is the last prayer?
My last prayer is let them be permitted to file the affidavit in opposition with all the essential documents. 1.
What?
2. Second is let the
I am
inspection
disposing of directing the authorities not to allow the private respondent number 8 to run the business without obtaining all the document necessary permission from the concerned authority.
One more in this, let the inspection be permitted in presence of them, as we are not permitted to at least inspect my own premises. What is there?
You go to the tenancy civil suit. That you go to the civil suit. The court. How the tenancy will be decided here?
Lordship, not the tenancy. The keys are in their custody.
Correct. Only your case is that they are running the business without obtaining the license. They are running the business. That's why you are apprehending that any untoward incident will happen. Now they have closed the business. So I am disposing of, and they are undertaking that they will not. On the last occasion, they also given undertaking they are not running the business, and that has been supported by the report of the municipal authority. Now I will dispose of the writ application, directing the respondent authorities to see the private respondent shall not run the business without getting all the necessary documents and permissions or certificates from the concerned authorities.
Lordship, kindly record that they have admitted that they have closed the business in the record. Deeply grateful.
The main grievance of the petitioner.
Yes.
The main grievance of the petitioner in the present application that the private respondent number 8 is running the sweet shop in the premises of the petitioner. And the grievance of the petitioner in the present date application that the private respondent number 8 is the tenant under the petitioner and is running the shop, sweet shop, under the name and style of
Bhakti. Mishtanno Bhandar. Messrs. Bhakti Mishtanno Bhandar.
Messrs. Bhakti Mishtan Bhandar.
Mishtanno Bhandar.
Without obtaining any permission from the competent authority. Police stop. And counsel for the petition submitted on the earlier occasion, the petitioner has filed a writ application. Filed a writ application being WP number 21205 of 2024, which was disposed of by this court by an order dated 11th of July 2025, wherein this court directed the West Bengal Pollution Control to take necessary follow-up steps positively within a period of 8 weeks from the date of communication of the order. In terms of the order passed by the coordinating branch of this court, the West Bengal Pollution Control Board has initiated the proceeding and passed the following order. Page 50, it according to na. Okay. Then counsel for the grievance of the petitioner and counsel for the petitioner submit that in spite of the order passed by the Pollution Control Board, the private respondent number 1 has not complied with the said directions and is still running the sweet shop without any permission from the competent authority by violating all the rules and regulations. Then counsel for by an order dated 7th of May 2026, The learned counsel appearing for the private respondent admitted that the private respondent number 8 has not obtained the certificate from the West Bengal Pollution Control Board and is not running the business at present. Accordingly, this court directed the authorities to file report. The chairman, Uttarpara Kotrang Municipality, has filed the report wherein it reveals that no business activities was seen at the site at the said address under the name and style of Bhakti Sweets / Bhakti Misthan Bhandar, and the said shop is under lock and key. Along with the said report, a photographs has also been enclosed, which shows that the said shop is under lock and key. So considering the above, this court finds that no purpose should be served by keeping the writ petition pending. Accordingly, the respondent authorities, particularly the respondent number, respondent 3, 4, 3 to 6, 3 to 7. No, 3, 4, 5, and 7. Not environmental ke jarurat nahi. 3, 4, 5, and 7 are directed to see that the private respondent shall not be allowed to run the business in the said premises without obtaining necessary permission from the authorities. If the private respondent obtain the certificate from the concerned authority with not to allow. From the competent authority. WPS disposal.
The order, the
report kept in the record.
Grateful. Deeply grateful, Lord.
Next.
And my lord, I am for the petitioner. My lord, that
Yeah.
matter, my lord, where lookout circular, my lord, was issued. The last occasion, your lordship at my lord directed me, my lord, to send a notice of.
Yes, who is appearing for the Union of India?
I am appearing.
What is the matter?
But at the instance of the Eco Bank, the lookout circular was issued. At the instance of the Eco Bank, lookout circular.
Okay. Acha, that one.
No, status is until unless the circular is clear. Until unless it is original request BOI will not cancel it.
No, but that's correct.
Yes.
But 2022.
Yes,
Kindly see LOC.
2022 LOC was issued.
And what?
Can you take page 6 of the circular? J, subparagraph J.
This is
the circular dated 22nd of February 2021.
Yes.
J says, the LOC open shall remain in force until unless a deletion request is received by the Bureau of Immigration from the originator itself. No LOC shall be deleted automatically. Originating agency must keep reviewing the LOCs opened in its behalf on quarterly and annual basis and submit the proposals to delete the LOC, if any. Immediately after such review, the BOI should contact the LOC originator through the normal channel as well as other online portal, and in all cases for the person.
So this has been issued from by as your request.
Yes.
So why it is? So you request to withdraw.
Fact said that no such step was taken. He had said that they were willful defaulters. Not even any proceeding for willful defaulter had been drawn up.
Let them request a VOI. VOI will delete it. There's nothing remains.
Observation. The orders for that.
Otherwise, I cannot do it.
Can you report this so that we can do it?
I cannot do it.
Your lordship, my lord, I have, my lord, found out, my lord, there are several cases, my lord, instances, my lord, where, my lord, the honorable court has, my lord, suo motu, my lord, quashed the circulars, my lord. My lord, I have got, my lord.
Can I record your submission?
Yes.
So there is no proceeding initiated against him. Either declaration of fraud or willful default.
And, my lord, no criminal antecedent, my lord. Your lordship, my lord, on the last occasion, my lord, inquired.
Petitioner has filed the present date application praying for direction upon the respondents to disclose whether purported lookout circular against the petition number 2, 3, and 4 have been issued out, and also prayed for quashing and setting aside of any lookout circulars issued against the petitioners at the instance of the respondents. Full stop. As per the direction passed by this court, the Bank of India, UCO Bank, the UCO Bank, the Learned Counsel appearing for the UCO Bank has submitted the request dated 31st of March 2022, addressed to the Deputy Director, Bureau of Immigration for requesting for issuance of the lookout circulars against the petitioners herein. All petitioners are here. Gopal Roy, Sabhyakam, they are the petitioners.
Yes, sir.
Petitioners here. Full stop. Learned Counsel for the petitioner, the bank submit that as per the request made by the bank, the lookout circular was issued on 21st of March 2020. First circular issued, then request have been made.
Well, request is on 31st of March, my lord.
But circular issued for prior 21st of, but the circular lookout circular has been issued on 21st of March 2022. Full stop. Learned Counsel for the bank submit that though the bank has requested the authority for Bureau of Immigration for issuance of the lookout notice, but no proceeding has been initiated against the petitioner either for willful default or declaring fraud of the account of the petitioner. Full stop. It is Learned Counsel for the petitioner submitted there is no case, no case is pending against the petitioner. Learned Counsel appearing for the Union of India. India has handed over the office memorandum dated, what is the date? Dated 22nd of February 2021, and submit that as per clause 6 within bracket G within bracket small j, within bracket J, not J, 6 within bracket J, the lookout circular open shall remain in force unless a deletion request received by the Bureau of Immigration from the originator itself. No LOC shall be deleted automatically. Originating agency must keep reviewing the LOCs open at its behest on quarterly and annual basis and submit the possible to delete the LOC if any. Full stop. Had the Learned Counsel for the respective parties peruse the materials on record. Admittedly, the bank has made a request to the Bureau of Immigration for issuance of the lookout notice on 31st of March 2022. But this court find that before receipt of the said request, the LOC has been issued against the petitioners on 21st of March 2022. It is the case of the bank that no proceeding has been initiated against the petitioner either for willful default or for declaring the account fraud. It is also admitted that no case is pending against the petitioner. Considering the above, this court find that there is no investigation initiated against the petitioner, nor any investigation report is filed. Accordingly, the lookout circular dated 21st of March 2022 is set aside and closed. Good.
They will accept the
No case, no proceeding declaring the petitioner as willful default or fraud is initiated, but requiry proceeding is only pending. I will Grateful. WP is disposed of.
My lord, I am for the petitions. My lord, I am enjoying an interim order, my lord, which expires tomorrow.
Yes.
My lord, my learned friend has not filed any affidavit in opposition till yet.
Yes. Yes, what is the submission? To file affidavit. Learned counsel appearing for the respondents prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. Reply, if any, thereto be filed within 2 weeks thereafter. List the matter on 3 weeks, 1 week, 2 weeks, no? 3 weeks, 2 weeks. List the matter on 5th of August 2026.
My lord, in this matter, my lord, I am for the respondent, my lord.
5th of
My
August.
lord, last 2 occasions, my lord, I took the time because there was no instruction, my lord. On 22nd June, I have received the instruction, your lordship. Kindly extend the time to file my opposition by 4 weeks, my lord.
3 weeks, 3 weeks, 3 weeks.
No, my lord, 4 weeks. This is not this frontier headquarter, Assam, my lord.
3 weeks. 3 weeks time.
Yes, my lord.
Interim order.
5th August. Great. Next.
My lord, well, it is that matter.
Yes.
My learned senior mentioned
When he
yesterday.
when he will come?
Monday, my lord. Monday.
Affidavit.
I'll tell you, Lord. From March, this matter is going on, your Lordship was giving them sufficient indulgence, affidavit, report, document, order. Now, yesterday night, my lord, we've been given, day before yesterday night, we've given an affidavit. Now, allow us to file an affidavit to the writ petition. It cannot be disposed of like this. Because every day they are coming up with new things.
We
That
have filed
pure
a
vote
supplementary
certificate.
affidavit pursuant to your lordship's direction, my lord. We have filed a supplementary affidavit
Very well.
stating, my lord,
Yeah.
that during that period from 2020 to 2023 regarding that certificate, renewal of certificate. So, my lord, we have filed an affidavit. We have
Yes.
served a copy upon it.
In substance, the affidavit says that there is no certificate.
And why it is not there, my lord? And why it
is
could
that
not be there?
issued?
Because no certificate was issued during that period by the peer review board for in respect of any peer review chartered accountant because of the COVID period. So, my lord, what happened during that period? We have applied to them what they have said when the meeting was held. I have explained that in that affidavit and I have given the
Okay, let me
communications.
file affidavit.
Yes.
I'll file a composite affidavit to all whatever they
Where is your affidavit? I file here.
Yes, may I file?
Affidavit
maybe
filed
get
by
a
the
copy,
petitioner
brother.
be kept with the record.
Yeah, WhatsApp पे जेटा था.
Learned counsel for the petitioner respondent. Press for filing affidavit in composite affidavit in opposition to the writ petition and the supplementary affidavit filed by the petitioner. Let affidavit in opposition be filed within 3 weeks.
My lord.
Reply, if any, there to be filed within 2 weeks thereafter.
No, 1 week, my lord.
1 week thereafter. List the matter. List the matter on 29 July.
Grateful.
Under the same heading.
But can it be fairly at the top, my lord?
Give that.
My lord, can it be fairly at the top, my lord? Subject to.
Yes, under the same heading within 10 matters.
My great.
Yes.
Lord, I appear for the petition. I'm led by Mr. Abhijit Mitra. My lord, he's on his way. My lord, I'm starting. Lord.
What is the matter?
My lord, this.
Tender.
My lord, this is the matter which I had mentioned, Lordship. The petitioner is a company which carries out dredging and desilting operations. But we've received a contract from the state, which is the executive engineer of the waterways department. My lord, to dredge a stretch of the Rupnarayan River. Lordship knows, my lord, it's one of the major rivers in the state, my lord, prone to flooding. As per the contract, Lordship, which Lordship will find, the contract starts at page 53, annexure P1.
Yes.
But selection of the contractor for the work dredging desiltation of Rupnarayan River. Now, Malad, this is very important. Under no cost to state exchequer model for a length of 15.20 kilometers. This was subsequently extended to 19 kilometers. Malad, under the revised revised award of contract. What happens here, Lordship? I do the entire work. I put the machinery, I go into the river. When I go into the river, I take out all the riverbed materials, which include sand, various other materials, and then I clear it. A certain part I have to give it to the state. The additional what is there is something which I can sell off. That's how the entire operation is sustainable financially, because the state spends nothing. Everything is at my instance. Well, may I leave it to?
Yes, Amraj. The issue is very small. We have been paying the royalty. I have to place an order. They issue something called permission holder ID. With that, I will get my royalty challan. Once I get the challan, I'll pay the royalty.
I'm afraid of seeing your hand. You are so moving that hand, I don't know.
Lordship, just now, Lordship said the other day, Franz Beckenbauer played a full match with his hands strapped. And Lordship reminded me of that. After that, I'm inspired. It's up to this weekend. Though, of course, I think that match, Germany lost that match.
Germany lost that.
Historic match. Next, thereafter, Germany won the World Cup with Franz Beckenbauer being the captain of the German team.
Yes.
So, Lordship, we paid, we asked for the permit. For each lot we lift, they raise the challan, we pay the royalty, and we lift the material. Now, Lordship, kindly come straight away to page 124. What's happened here? Page 124. I'm being as short as possible because here I don't think there's any dispute. 124, the executive engineer says, in reference to the above, because I've been doing this for last 6 months. Above, enclosed herewith award of contract along with 2 numbers filled up pro forma of annexures to create permission holder, each in duplicate in favor of reach that is the petitioner, with the request to create a permission holder.
Which page you are reading?
Page 124.
124.
124, that is 4th of P14, that is 4th of June.
Yes.
This is from the executive engineer to the
Chairman, managing director.
In reference to the above enclosed herewith award of contract along with 2 numbers of filled up pro forma of annexures to create permission holder in favor of reach dredging, that is the petitioner, with the request to create a permission holder module in favor of them for paying royalty and other levies for desilted bed material against the above mentioned works. This is sent to the WBMDTCL, and he raises that permission holder, like it's been doing earlier. Lordship kindly takes a look at 1 or 2 earlier ones, then Lordship will, for example, 116. Lordship kindly comes to page 116. Same letter, issued in January 2026.
Yes.
And Lordship, then WBMDTCL 119 raises the challan in connection with the
So then what has happened now?
Like, so each time we would get that challan, we would pay the royalty and then the lift. Just silence, radio silence from 4th of June. And Lordship, the irony of it all is that on 1st of June, Lordship, page 133, they had written you lift more quickly, page 133, 1st of June.
Slow progress.
You'll see the last 3 lines. You are therefore requested to expedite the work immediately and enhance the progress of the work.
Yes.
And I have a 2.5 years contract. And I've acquired 4 dredging machines. My works are fully deployed, so then immediately we also. Now, why is the radio silence? Because this is how it's done is on the river side we have taken a site where we lift and we keep it there. Once we pay the challan, we can remove it. Once we pay the royalty. Now my stackyard is full.
Now, with the rains, heavy rains, it's getting washed back into the river. And now I also can't take out more. So they are rushing us. Like, why is, well, I don't know why are they sitting tight from 4th of June 24.
So
page
what is the request? What is the prayer?
My prayer is to issue the challan. Lordship, kindly page 120.
Issuance of challan.
Yes, Lordship, request to create permission holder. It's a very complex system. Permission, Lordship, see page 124, whatever the executive engineer said. And yes, Lordship, that is my prayer. Be also page 48. That is exactly on the lines. Very, very unusual words, very difficult to remember because no nexus. Last two lines with the request to create a permission holder module in favor of them for paying royalty. For each quantum we lift, there is a permission holder module. Without that, I cannot pay royalty. Okay, I can show one earlier permission holder module. Lordship, kindly, Lordship sees what is, these are issued page 121. It is, this is what is comes from the, of the portal, we pay the royalty. And once we pay the royalty, 120, Lordship, kindly give me 1 minute. Page 119 is what WBMPTCL does. 119, which is what the request has been made by the executive engineer. Page 119, the earlier one of the instances, in connection with the subject and reference mentioned above, this is to inform you that user credential has been created in favor of reach dredging for disposal of 25 lakh CFT of contractor share of materials in the first tranche in the online portal and shift it to your end for approval. Hence, you are requested to kindly follow the guidelines issued by memo so and so while approving requisitions through the online portal. Once I get this, once this is issued, copy given to me, page 120, I then forward this to the ADM DLRO. With reference, husband is informed that reasoning has been awarded in order to start online procedure with your good self.
You requested this.
You are requested. And then next page is the form is given and I put in the royalty and I remove the material. This is in terms of the contract. This is, and this I have to remove altogether.
Where is the term?
Yes, that is page.
Page 73,000.
No. Page 53 it starts at page.
Condition. Where is the condition?
Yes, condition page.
For stocking and removal.
So kindly give me 1 second. Page 73.
So clause 8.1.
8.73, page 8.1. 8.1, page 73. The contractor, after sharing the volume of silk with concerned division, as quoted by him, may utilize the remaining volume of silk at his own discretion by making payment of royalty.
So you have with regard to the shares.
As and when the request we will give them, because that is mentioned also 1 lakh odd, that is where is it mentioned? 1 crore goes to them and the rest come to us. That is not the allegation or any objection from their side. Where is that quantity? Page 115. Page 115 is there. It is the government's share. That is total dredging is 45 crores and government's share is 2 crores. That as and when we give them. Now the rest we remove against royalty in terms of clause 8.1 at page 73.
Yes.
So I just need to pay the royalty like I have been doing each time. And for payment of royalty, this permission holder or whatever they call it.
Now, with regard to the volume of the earth to be shared by the government, that has been given to the government.
That as and when the government asks, we give. So there is no grievance. There is no grievance. Their grievance is page 133 that you expedite the process. From out of their quantum,
As and when they require, give them. There is no.
What is your instruction?
So I am for the corporation who maintains the portal. The agreement is with the irrigation department. Now, based upon the letter dated 4th of June, it was forwarded by the, on the basis of this request, steps have been taken. After all, this portal is operated by NIC. We have taken up the issue because this time the quantity was enhanced to a much larger scale. Steps have been taken. My instruction, within next 7 to 10 working days, it will be operated. So far as this slow progress is concerned,
keep it without your lordship.
Slow progress is concerned, that is much prior to the date of issuance of the request, because the initial work order was issued in January.
I've been regularly.
From the record, it appears that the irrigation has requested them that within the more than 5 months they have extracted only less than 1% of the.
So I would extract more. You give me the share, I will extract more. Give it to me to
Preparing for whom? You are
1 and 2.
So I am recording your application.
Lordship,
This under process,
yes.
request of the petition under process. So that's why I am adjourning the matter for 10 days.
Yes.
The pendency of the writ petition will not prevented you to take appropriate decision.
Yes, but we have already, so far our part is concerned, that has been done. Now it is for the.
Well, I was requesting 7 days as they said, because my business was
7 working days. We not
that. The only grievance of the petitioner in the present application that on 4th of June 2026, the petitioner has requested to create a permission holder model in favor of requested to create a permission in favor of the petitioner for paying royalty and other levies for desilted bed materials against the work awarded to the petitioner. Learned counsel appearing for the respondent number 1 and 2 submit that the request of the petitioner is under process and it will be cleared within a period of 1 week. Within a period of 7 working days. Considering the submission made by the counsel for the respondent number 1 and 2, the case is adjourned till
Lordship next week, Lordship next Thursday or Friday, Lordship kindly keep it. We will know by them.
Till 3rd of July 2026. Let the matter appear on 3rd July under the same heading within 10 matters. Full stop. The pendency of the writ petition will not prevent the respondent authority for taking appropriate stuff for creating the permission as per the request made by the petitioner of 4th June 2026. This is the matter.
Affidavit of service I'm keeping on.
Affidavit of service. Next.
My lord, I appear for the petition.
Who is for the petitioner?
I appear for the petitioner, my lord. My lord, I'm filing my affidavit of service. My lord, I'm led in this matter by Mr. Ishan Saha. My lord,
It's a prayer.
My lord, my prayer, my lord, is for release of amounts under the Sukanya Samriddhi scheme. My lord, kindly makes it not today, my lord. I'm led by Mr. Ishan Saha. And
yes.
In some difficulty.
Sukanya Samriddhi scheme. Items ruled by the government law.
My lord, I
will not pass any order. Don't worry. No. You tell me what. Let me see what is the grievance. What is the objection of the respondent? Page number 37.
Applicability of post office.
Page, cross. Application of posts. Yes. Yes, opening of account. So what is the condition? He is not in.
Great. My lord, let's see the
Why
2014
American people want the benefit of the Indian citizens?
because my person of Indian origin, my lord, is aware of
American people, why this is Sukanya Samriddhi scheme?
because they don't have socially beneficial legislations like that, my lord. Yes, no doubt about that.
So
Kindly see the extant rules at page 36, my lord. That is the 2014 scheme. If I may just attract your lordship's kind attention. Kindly see the definitions, my lord. This is the scheme of 2014.
Yes.
Kindly see section 2D, depositor.
Yes.
Means an individual on behalf of a minor girl, child of whom he or she is the guardian, deposits money in account under the rules. Kindly see there is no embargo regarding citizenship. Then my lord will kindly see 4 account opening. That is at page 37. Account may be
They are
opened.
relying upon the 3 application for the post, the provisions.
Yes, I show your lordship the rules also. Kindly see the parents, my lord, scheme as well.
Yes.
Opening of account. The account may be opened by the natural or legal guardian in the name of a girl child from the birth of the girl child till she attains the age of 10 years. And
But
any
the girl
girl
child is Indian or this is also American?
Nothing is written. The girl child is American.
American.
Yes. Because the parents are American, my lord.
Then?
So, my lord, there is again, kindly see there is no embargo with regard to the citizenship here. Now, my lord, may I request your lordship to kindly take the rules directly. The rules are at page 54. These are the 1981 rules.
Yes.
If your lordship will kindly come to rule 3 at page 56. It says, a depositor desiring to open an account in the post office savings bank may make an rule 3, my lord, at page 56 of the 1981 rules.
They're not there relying. Yes.
Yes. Depositor desiring to open an account in a post office savings bank may make an application to it in Form 1. Non-resident Indians are not eligible to open an account in a post office savings bank. So this is not a non-resident Indian. This is an American citizen.
So
my non-resident Indian cannot be. It is a question of domicile. Kindly appreciate, my lord. It is not an embargo on citizenship. It is an embargo on the domicile. It is an admitted position also that the account holder, my lord, was domiciled in India.
Then it has to be decided on affidavit.
It has to be decided. I have no difficulty. If your lordship will kindly take my prayers. Kindly take my prayers, my lord. I have made a representation to them asking for premature closure of my account because I want to pursue higher studies. The rules allow that. They have responded asking me to clarify my citizenship status. I have responded. They have after that not said in the affirmative or negative whether I am entitled to any benefit. And I'll show your lordship from the scheme, my lord. Scheme says if the account is opened contrary to the regulation.
That is a representation.
Yes, I'll show your lordship, my lord.
130.
I'll just show your lordship, my lord. If your lordship will kindly first take page 127, 16 June 2025.
Yes.
I have made an account closure request. If your lordship will kindly take the next page at 128, the respondent writes to me. Kindly see on 18th August 2025, they are writing. Subject is closure of SSA account VD such and such regarding. Dear Ms. Pujara, in compliance with letter such and such dated 24th July 2025 of the SSPO South Kolkata Division and in connection with the above mentioned subject, you are requested to intimate this office whether you and your guardian were citizens of India at the time of opening the said account, and the relevant documents may be supplied to this office in support of your statement on the same for taking further course of action from this end. So this is what they write to me. Page 129, I responded to them, my lord, clarifying. Then, my lord, my last letter and my most conclusive letter to them is at page 133. 11 December 2025 written. Very detailed, my lord, giving the antecedents of past correspondence, etc., saying that, my lord, I was not an Indian citizen, I was a US citizen. But that there is no embargo under this act.
So that is to be decided.
Yes, so they have not taken any decision. If your lordship will kindly take
No,
my,
if you wanted that it has to be disposed of by considering the request, then I will dispose
your
of.
lordship could direct and then keep it pending, my lord, as your lordship directs, my lord, because they have not taken any decision either way. Otherwise, my lord, if your lordship is pleased to direct affidavits, lordship will decide it on affidavits.
File affidavit. Let
Please,
it
my
come
lord,
to
no
me.
difficulty, no difficulty.
The
Only one thing, my lord, may I just urge before your lordship. I have also a prayer for release of the principal amount, because the dispute will only be with regard to the interest. Because, my lord, there is some kind of financial stringency. If I may show your lordship the regulation,
principal amount. Why the principal amount is not
kindly
released?
direct that, my lord.
Full stop. The respondent authorities press for respondents press for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. 3 weeks. Reply, if any, there to be filed within
1 week, my lord.
1 week thereafter. Full stop. The counsel for the petition submit that the principal amount of rupees 18 lakhs maintained by the petitioner in account number 2804843951 open with the Sarad Post Road Post Office under the Sukanya Samriddhi account rule 2014 is lying with the respondent authorities, and as such the petitioner prays for release of the principal amount by keeping the interest principal amount. Land counsel for the petitioner submit that the respondents will release the principal amount in favor of the petitioner. Considering the submission made by the counsel for the respondent, who will release?
Who will release?
Who will release? Respondent number?
Account is with the post office, my lord.
Huh?
Yes, my lord.
The respondent number 1 is directed to release the principal amount of the petitioner within a period of 1 week. Within a period of 2 weeks from date. Release the matter on 30th July.
Extremely grateful.
Lordship.
Earlier, previous government I served twice. Now, since there is no clarity who is going to be appearing, so my lord, I have taken.
Which department?
No, these are all land related matter. I have taken a little bit of risk, my lord. I should be candid. I wanted that let them come. Then, my lord, I will. If they could download it from the Sarthok, because these matters, my lord knows, my lord, client they don't contact. Some matters where there are opposition reply, I will serve them. But where there is nothing, they should download, and whoever is appearing, my lord, because what I come to know, because matters are not being, my lord, allotted by the GP, because there is no functional office of the government PIDA, perhaps, what we could hear in the corridor.
Why?
So I don't know, my lord, I can't comment on that. But the difficulty is that matters are piling up. We serve, nobody appears. Each court matters are getting adjourned. So I could not serve these 30 matters again and waste those things. So, my lord, if whoever is appearing, I'll give all the copies to her, my lord.
Yes, you are appearing.
I'm a, my lord, appearing for
Union, there's no change. If the problem is with the state.
You are appearing for whom?
My lord, I am appearing for Union of India.
Both.
Who will
Led
replace?
by
Union of India in 8 matters. There is so many matters, about 28
Lord, these are all, Lord, I tell you also what is the issue. Lord, these are land acquisition matters under the National Highways Act. My lord knows, my lord, that under Schedule 4 of the 2013 my lord, Fair Compensation Act, National Highways Act is enlisted. Section 105 says that the government may notify and, my lord, apply the Schedule 1, Schedule 2, and Schedule 3 to the acts notified in Schedule 4. That has been done in 2018. These are all acquisition cases in National Highway. What we say that, my lord, it's a bulk arbitration case. Now, one arbitrator takes up the entire moja, passes one award. That cannot be done because 3G6, it has to be separate arbitration. Second, the first schedule, that is the compensation solution, that could be paid. But the second schedule, that the arbitrator cannot give because he can only increase and decrease the compensation, the land to land or house, other compensation. And that's the legal challenge before my lord. So whoever is appearing, whoever takes responsibility, my lord, I am ready to give a copy. My learned friend is there, my lord.
Therefore, the Union of India.
No, that
you are appearing for.
So, my lord, what I can do is I will serve all these matters. My lord may direct me, since there is no one appearing today, to serve my lord on the government period directly and request him that he engages
No
somebody.
purpose will be served.
No purpose will be served. Then kindly see our position, my lord.
For the last 1 month, I am passing the same order, but again the same. Now, I directed the legal remembrance. Now she has been given this code. And initially she is stating that I am for the state. What is the meaning of the state? Now she is appearing for whoever this. Now she is appearing. I don't know whether she is getting the instructions or not.
What I can do is I can serve this on her. She can get it regularized.
Yes, you
or
give
or that I
no,
think.
she is
that-
appearing. See, you do one thing. You give all the copies to her.
But may I beseech your lordships to pass a single line order that since she is here,
yes, I will.
My lord may engage her in all the matters, direct me to serve it on her. She will not. My lord may regularize.
Take instruction, and if any other senior will
Otherwise,
come or whatever.
it will go to the cold storage. The other and fixes the date after 15 days whenever she can come ready.
That's why I'm specific. If this court finds that.
But she is a junior government advocate. She can represent the state alone.
Yeah, that's what I'm telling
She
you.
doesn't need a senior also. It's better. Naam phone number likhe na.
So appearing for the Union of India. Full stop. So appearing for the state. But she submit that she is not having the writ application and its annexer. Full stop. Accordingly, the petitioner is directed to serve the copy of the writ application along with its annexes and if other documents, if any other document be served to the learned advocate appearing for the state when within a week.
Yes.
Within a week.
Miss Sudeepa Banerjee, junior government advocate.
Recording. Within a week. Okay. Within a week. Affidavits filed, na?
Yes, some of the matters report filed, some matters nothing filed. Whatever is there, we'll do it, Lord.
Let the matter when August.
Whenever your lordship's diary may permit, not any date.
Let the
And
matter. 24th August at 2
এগুলো
p.m.
এফিডেভিট হয়েছে একটু আমায় দিয়ে
সব দিয়ে দেবো মিলট মে আই kindly direct me to serve directly on Sudeepa Banerjee.
Yes, I recorded.
Yes.
Appearing for the state, the petition director served the learned advocate appearing for the state.
Yes.
much obliged.
Otherwise it will go to the GP office and it will be piled up.
No purpose would be served. Because one day I called the GP also. That I find this situation. Looking the GP, then I find that he is helpless.
I think they are trying to not come out of this clutch. There's a very small panel prepared, I think.
Because though it is a big state, when I was in government, before the government period, when I was in the panel, so whenever panel changes or my department changes, it is my own. I prepare the list and handing over to the department, and the person, the advocate who is appearing.
Erstwhile lawyer will give it to the directly.
Correct.
Why
That is,
the
here they are not.
problem?
No, today AG was present in one matter. AG is telling that there is no brief.
No, I don't want to say anything. Before your lordship is accepting our submission saying that you get it download from the Sarthak. But in some other places that is not being accepted. We are serving again and again. That's a real problem for all of us. But I'm grateful to lordship. কত August? 24th.
Yes, call the next.
But 14 and 15 মিলাট কি হলো তো সার্ভিসটা দেবেন Lord, we have served upon the GP as per my lord's last order. Oh, you are- Then in that case, my lord may kindly take some.
What is the matter?
My lord, it's my lord permission, my lord, seeking to proceed with IVF. Your lordship had asked me to produce the marriage certificate and the documents previously, prior to the process of seeking IVF. We have filed a supplementary affidavit in which, my lord, we have annexed the marriage certificate as well as the my lord, documents prior to obtaining, my lord, the process of IVF.
সাপ্লিমেন্টারি এফিডেভিটটা
সাপ্লিমেন্টারিটা আপনাকে দেওয়া হয় আছে একটা কপি আছে এক্ষুনি দিয়েছি
Yes.
Lord, the wife is at 14 wife is aged 49, my lord, just at the threshold. Husband is above the threshold, my lord, and we have annexed the medical documents. We have pleaded that we are financially sound, and my lord, we have also made a representation that's at page 30 of the writ petition. And your lordship may kindly please, if my lordship is pleased to take up the supplementary affidavit, your lordship will find the marriage certificate as well as the documents, my lord, prior to availing or, my lord, issuing the demand justice. The petition, the couple, my lord, failed to obtain naturally. That is why, my lord, as a desperate measure, they are seeking this step.
Yes. Yes, madam.
My lord, I have contacted all the authority, my lord, but no one give any response.
My lord, may I say, my lord, one thing, my lord, may I say one thing, my lord,
There
with
is a
deepest of respect, private respect has no role. My lord, with deepest of respect, my lord, state, my lord, even they, my lord, what
Where is the
instructions-
judgment? Don't have that.
Your lordship only told me on the last occasion. I thought my lord will be having.
My lord, what I have learned from this act, my lord, according to them, section 21 G1 to woman above the age of 21 years, to the age of 50 years is permissible. But to a man above the age of 21 years and below the age of 55 years.
That has been taken care of.
Here, the petitioner's husband is 57 years, man.
That has been taken care of, my lord. I have referred that judgment in paragraph 13 of the writ petition. I am having copy to you.
Not having the judgment.
Don't have the copy, my lord.
My lord, I have that copy. Amrita Sena.
But which copy? Which judgment?
This one only, this one.
That
has taken care of the fact that even if husband is beyond the threshold, if his sperm quality, my lord, is within the parameters, then nothing is to be seen. Because the woman is the carrier of the child. So women's age is the threshold criteria.
Yes.
My lord.
Lordship may kindly passes a composite order in both the matters.
Where is that wife?
My lord, wife is 49.
Where is that order? That certificate?
My lord, at page 28, your lordship may kindly see I have annexed.
Where is the doctor certificate?
Doctor
clinical charges. When you went to when the marriage was solemnized?
My lord, marriage was solemnized, my lord, on, kindly gives me a moment. My lord, February 14, 2002. That's I've pleaded paragraph 3 and annexed at page 4 of the supplementary affidavit.
Where is the date of marriage? Page 4.
Milord, at page 5, in between it's written, Milord. Schedule A, page 5, on 14 February 2002. Has my lord found it?
Yes, then.
And Milord, from page 7 to page 26 onwards, Milord, are the medical various prescriptions, Milord, tried before to conceive naturally but failed. Thereafter, Milord, IVF was required.
Now, where is the doctor's opinion that the lady is able to conceive? Yes, Milord. Yeah.
Seventy-eight नहीं 78 কোন page আরে এটা রিট পিটিশন আছে রিট পিটিশন আছে
Where is that?
Lord, may kindly kiss you. 18. At page 18.
Page 18 of writ application?
Writ application.
Where?
Lord, advice. Plan, Milord, IVF and something.
Where?
Milord, in between, Milord.
Updated Aadhaar available.
When updated
Page
Aadhaar?
19.
Yes,
18.
page 18, Milord.
When Aadhaar update.
Milord, just at the left hand side, plan, IVF, and thereafter something else is in gibberish it's written.
The petitioner has filed the petitioners have filed the present application. Okay, praying for the direction.
Yes, surrogacy.
Praying for permission to avail assisted productive technology through IVF procedure upon obtaining ovum from concerned bank in terms of the provisions of the ART 2021. Counsel for the petitioner submit that the marriage between the petitioner number 1 and petitioner number 2 was solemnized on 14th of February 2002. Since after the marriage, the couples were not blessed with any child. Accordingly, since the year 2024, the petitioners were under medical treatment to have a child, but it was found there, but could not succeed. Now they have taken a decision to have a child through assisted productive technology and through IVF procedure. Land Council for the petitioner has disclosed the document which reveals that since the year 2024, the petitioner number, wife is the petitioner number?
Number 1.
Petitioner number 1. Petitioner number 1 is under medical treatment, and it was found that the petitioner number 1 is able to conceive the same, but can adopt can adopt IVF procedure, adopt the IVF procedure, but the petitioner number 2, the husband is aged about, what is the age of the petitioner number 2?
Lord 57.
Is aged about 57. Is aged about 57. And as such, the clinic has advised the petitioners that it is not possible for the clinic to go for the IVF procedure as the petitioner number 2 is above the age of 55 years. Accordingly, the petitioner has filed the present application. The petitioner has relied upon the judgment in the case of Shyamoli Shah and another versus the state of West Bengal and others passed in WPA 23776 of 2024, and submit that in the similar circumstances, the coordinate bench of this court has allowed the parties to avail the facility of ARTS and directed the concerned authority to provide such facilities. Learned Counsel for the state submit that though the petitioner number 1 being the wife is aged about, what is the age of the petitioner number 1?
49.
49, but 50 years stated. 50 occurred this 50.
Page 18.
Affidavit, supplementary affidavit.
Yes, my lord.
Is aged about.
নাকি তো বছর আছে এটা কি কথা বলেন আপনি
50 years. Woman is 50 years. So she attained the 50.
Yes, my lord.
Then
my lord is the threshold.
Submit that petitioner number 1 being the wife is the 49 years, but the petitioner number 2 is aged about 57 years, and as such, as per section 21 GII, no order can be passed for availing the facilities of ARTS. Full stop. At the learned counsel for the parties peruse the materials on record and the document denied by the petitioner. Admittedly, the petitioner number 1 is according to the Act, the service is available to the women above the age of 21 years and below the age of 50 years, and the men above the age of 21 years and below the age of 55 years. Though the petitioner number 1 is within the prescribed age limit, but the husband fails to meet up the age criteria, as he is aged about 57 years. 57 years. The document submitted by the petitioner found that the petitioners had been to the hospital, has obtained the clinical report wherein the doctors have confirmed that the petitioner number 1 being the wife can go for the ART facilities. Full stop. Assisted reproductive technology within bracket regulation rules 2022 provides for reasonable checks and balances. A consent form is to be signed by the couple or woman disclosing their acceptance of ARTs. The prescribed form is specified that there is no guarantee that the OCTs will be retrieved in all cases. The OTCs will be fertilized, and even if there were fertilization, the resulting embryos would be of suitable quality to be transferred. The couple or woman is made aware the risk of the procedure involved. Full stop. There is no assurance that the pregnancy will result the delivery of a normal living child, and the uncertainty of the outcome of the procedure is fully explained to the couple. Full stop. As per the Act, The commissioning couple means an infertile married couple who approaches the assisted productive technology clinic for assisted productive technology bank for obtaining the service authorized of the said clinic or the bank. Full stop. Gamete donor has defined as a person who provides sperm or octave with the objective of enabling the infertile couple or woman to have a child. Patients has been defined as an individual or couple who comes to an restricted assisted productive technology clinic for management of infertility. Woman has been defined as a woman above the age of 21 years who approaches the assisted productive technology clinic for assisted productive technology bank for obtaining the authorized services of the clinic or the bank. Full stop. Section 21G of the Act bars the clinic for applying the assisted productive technology who does not meet the prescribed age criteria. In the present case, the petitioner number 1 is within the prescribed age limit, but the petitioner number 2, husband, is overage. Due to overage of the husband, the clinic is refusing to provide the service to the couple. The term patient in the Act permits the individual to avail the facilities of assisted productive technology, irrespective of the gender. The Act does not bar the individual partner or partner of a married couple to avail ARTS independently. The same implies that the parties to a marriage may avail the service either individually or jointly. Full stop. It is not necessary that the service has to be availed jointly by the married couple. Full stop. There is no provision in the Act which bars a married woman to approach the clinic individually for availing the benefit of ARTS. Full stop. The bar will not have any effect if the wife approaches the clinic to seek the service unilaterally. Full stop. The clinic or the bank does not have any authority to refuse services if a single partner of a married couple intends to avail the service. Full stop. Had the petitioner number 1 approached the clinic individually, the clinic could not have refused to provide ARTS to her. Full stop. The medical report of the wife discloses that the lady is physically fit to hold the embryo. The documents annexed to the writ petition reveal that the medical health of the husband is unable. No, get it there. But embryo, but the petition number 2, who is the husband of the petition number 1, is overage in terms of section 221G II. Full stop. Full stop. The legislature, in its wisdom, has prescribed an age limit to avail such services. The reason for such prescription seems to be reasonably sound. In the absence of the proper restriction and supervision to check the defaults, there is every possibility that there will be a misuse, and very purpose of providing such service will be frustrated. At the same time, the law cannot be interpreted to apply it in such a manner that the same becomes workable. In the present case, the woman is in the present case, the petition number 1, being the wife of the petition number 2, is eligible to avail ARTS in terms of section 21G within bracket small I. For the ineligibility of the husband, the wife ought not to suffer. This is so because the husband has no physical participation in any procedure involved for the birth of the child through ARTS. The husband has claimed that he is ARTS. Full stop. Full stop. Considering the above, this court finds that the petition number 1 is eligible. Petition number 1 being the wife of the petition number 2, so eligible to avail the facility of ARTS. Under such, the which authority? They have made a party. Authority. Clinic has been made a party.
Clinic has been made a party.
The respondent number 4 is
5.
directed
Respondent
to
number
provide.
5.
Where? 4.
Point number 5, Rashmika fertility.
4.
Oh, I'm sorry, respondent number 4.
Respondent number 4 is directed to provide such facilities to the petitioner. Did petition is disposed of. Both are same.
Next is surrogacy. IVF failed. We have the certificate that surrogacy is necessary. So most of the pleadings, only age will change. Otherwise, most of the thing.
Age change.
Your Lordship, may kindly just.
Where is that?
Yes, the certificate is at page 22. Last line it's written IVF failed, hence undergoing surrogacy procedure as an advanced treatment for fertility.
Fertility. So same thing will go.
Yes.
But here is also the husband of the petitioner age is 56 years.
Here the petitioner number 1 age about
49 and husband is 56.
Husband is 56. Okay.
And my lord, sorry, I'm troubling my lord again. My lord, on the last occasion, your lordship had also directed similar 2 matters to come to today. Not come. I'm just giving the item numbers if my lord may kindly includes on the next day whenever possible.
यार ठीक हम एक साथ रखो बोलते आप लोग फिर से अलग अलग कर देते पिछला बार हम पूरा लिस्ट बना के दिया था मंथली लिस्ट ना আমি লিস্ট দিচ্ছি আপনার কোথায় চলে গেছে হবে
Your lordship had directed your lordship had passed an order also in these matters.
चलो next
actually wait for me.
I appear for the petitioner.
I appear for the respondents.
We have arrived at an agreement. We have arrived at an agreement in terms of the that may be passed by this honorable court.
And
what agreement?
This was in respect of a delisting order, temporary delisting order. Similar matter had been considered by your lordship's court and previously directed that an inspection is to be carried out by RDSO. And if my learned friend is agreeable to that suggested order, we may come back before your lordship. To that extent, there is an agreement.
Agreement also entered.
Oral agreement between the councils on instruction.
Suggested order. This is suggested.
The allegation was certain equipments had to be upgraded.
Yes. These are corrected order.
Yes. Factually, there is a little alteration so far as the facts are concerned.
No, this is
the pencil correction is not the
pencil correction है ना वो कर ठीक है कर देगा
grateful
pencil correction
item
next.
Trial for the writ petitioner in this matter. My lord, the facts of the case is this, my lord, the petitioner is a company, my lord, which has entered into an agreement with the private respondent number 5. Now, private respondent.
My lord, adjournment and some time, my lord, so that I can take some instruction.
My lord, my grievance is not against the railways. My grievance is against the private.
Just let I will if necessary I will adjourn, no problem.
My grievance is
yes.
against
What is your grievance?
My grievance is against the private respondent number 5, who is a central public sector undertaking. Bisha Stone India Private Limited, a subsidiary of the Indian Railway, Ispat Nigam. My lord. It's a statutory body. Now, the thing is this, my lord, the private respondent number 5 has entered one private siding agreement with the railways. Now, under that railways, both of them are responsible for joint maintenance of the tracks for smooth ingress or egress of the railway wagons. Now, my lord, I am a company, my lord. I have entered a separate agreement with private respondent number 5 for the purpose of extracting mines, crushing them, manufacturing, and just putting those manufactured products over the wagon. Now, my lord, it is an admitted position. I will show it to your lordship that the tracks were not in a proper condition. Now, my lord, a derailment occurred.
So what is the
I want is this, my lord, without forming any inquiry committee, without any investigation, the charges of derailment has been levied upon me, without giving me any opportunity of hearing. And my lord, if
who has passed the order?
My lord, kindly see.
Where is the impugned order?
Impugned order, my lord, kindly see. For page 66, lordship, kindly see for once. They have not attributed anything against me. Page 66.
Birsa Stone Lime Clean.
64, my lord, page 64 for once. Sorry, man. Pardon me. Page 64. My lord, derailment occurred. Why? Why?
But who is appearing for the?
I have served. I have served.
The 5.
I have served.
Where for the, my lord, the Union of India?
Union of India, private my lord, I have served. Not only at the time of filing, but also after mentioning this matter, my lord, when your lordship was pleased to take up this matter today, I have again served and filed my affidavit of service.
So this has been written to the divisional railway manager.
This has been written to the divisional railway manager where there has been no attribution of any fault on me.
Correct. Whether the divisional manager has, whether the railway authority has taken any action.
1 to 4 months.
Yes. Have you taken any action in on the?
My lord, what they have done is this: they have
just a minute.
My lord, what from I have learned from my learned friend submission, that this is a matter of the derailment charges.
Yes.
So, my lord, the derailment charges that is related to the transportation. So, I think, my lord, matter is to be heard by the honorable court, wherein the determination of Group 7 matters.
No.
And your lordship's determination is in respect of Group 9 matter.
Well, I am not asking for any rates.
আমাকে বলে নিতে দাও না। My lord, the matter is related to the transportation. For this reason, my lord, the derailment was happened. And derailment is under the, my lord, the Group 7.
No, my lord, I strongly object.
No.
Group 7
And my lord,
matters.
apart from that, my lord, I think, my lord, the respondent number 5's presence is there.
Correct. That's I'm asking whether.
Yes.
First
This
of all, the
presence, I
respondent
don't
number
know, my
5 and whether the respondent number 5 has requested you have taken a decision as per the
My lord,
request made by the.
For this reason, my lord, at the very beginning, I have prayed before the lordship for adjournment to take some
Your
instruction.
lordship kindly see page
And my lord,
67 for once.
Let how without the
My
respondent
lord,
number
I have some urgency. My
No,
lord.
nothing.
No. Why I am saying so is this: they have threatened me and they have imposed 1 crore 7 lakhs
Correct,
upon me, and I
sir.
have substantially deducted a portion.
Correct.
Now they have threatened me further. My lord, kindly see why I am page 69. Kindly see, my lord. This is because of this reason I am before your lordship. With reference to the above, we would like to inform you, lordship, page 69, that as per derailment bill received from the Office of Assistant Divisional Finance Manager, Southeastern Railway, Chakradharpur, we have debited an amount of 1 crore 7 lakhs from the books and accounts on January 2026. In the meantime, we have received reminders from the Office of Senior DFM CKP towards payment of outstanding derailment charges to avoid inconvenience. For smooth movement of railway rakes, we have paid an amount of rupees 19 lakh 98,000 and on 16th of April, rupees 50 lakh respectively. The Railway Authority also received 20 lakh from RSP freight account. So the total amount paid against the derailment charge is 89.98. The total derailment amount 1 crore 7 lakhs will be adjusted from the monthly earning bills when I have nothing to say, nothing to do.
Yeah, this is April.
April, my lord, they have already deducted 50 lakhs. I have no agreement with the railways for maintenance.
This is a letter of April. No, we
My
are.
lord, they can any day they can deduct.
Correct.
Kindly protect me for that time.
Correct. Let he take instruction. I am keeping on the next week, and he again inform the date to the respondent
for
number
the
5.
time.
If they will not come, then we'll see the.
My lord, calling only for 7 days. My lord.
The petition has filed the affidavit in affidavit of service. Service, let the same be kept with the record. In spite of service of notice, none appears on behalf of the respondent number 5. The Learned Counsel appearing for the respondent number 1 to 4 prays for time to take instruction. According case is adjourned, let the matter appear on 6th of July 2026. Full stop. Full stop. It is made clear that the petition is directed to inform the next date of hearing to the respondent number 5. It is made clear that on the date fixed, if none appears on behalf of the respondent number 5, appropriate order will be. Next.
My lord, your lordship fixes that on 6th of July. Lordship, some preference may be given
Under the same heading.
Great.
Next.
But I pay for the petitioner.
Yes.
But this matter, my lord, was moved on 16th of May.
Yes.
It was a Saturday, my lord, therefore, my lord, it was assigned before Honorable Single Judge.
Yes.
But kindly have a look to the order, my lord. But the impugned order, my lord, was, my lord, the fire department suddenly, my lord, issued a notice, my lord, directing, my lord, the inmates of a particular building, which is a very old building, to vacate the building on the ground that there were no fire safety equipments. Now, my lord, this was moved before, if your lordship may kindly have a look to the impugned order at page, P4 page, at page 68. Please have a look.
Who is appearing? You are appearing?
Yes, sir. But to cut the matter short for today, Millard, there was a direction on 16th of May. If your lordship may kindly have a look, Millard.
Yes.
Can you take me at page paragraph number 14? Or if I may read from paragraph 12. Having considered the submissions made on behalf of the petitioner and taking note of the provisions contained in section 37A1 of the Act, the court prima facie finds that the respondent number 2 is required to record satisfaction prior to passing the said order directing the petitioners to vacate the apartment. Then paragraph 14, at the first blush, on perusal of the impugned order, it appears though it is spelled out that inbuilt fire safety installations have not been found at the premises in question, but what were the materials available before the respondent number 2 for passing the impugned order are required to be considered by the court on the next date. Moreover, in terms of section 37A, the respondent number 2 is required to record satisfaction before inferring that there is imminent danger to persons, etc. And then His Lordship was pleased to state, Millard. Today, Millard, I was requesting your Lordship, Millard, to call upon my learned friends to produce these materials which were the basis of the satisfaction.
Yes.
Now, Millard, the impugned order, Millard, if your Lordship may kindly take, Millard.
So now, whether you file affidavit?
My lord, I have the report. My lord,
have you served?
My lord, before my lord, before placing to your lordship the report, I concisely submit 2 or 3 things before your lordship. My lord, the name of the apartment is Ponchoshila apartment. The allegation is floated relating to the ground floor, located in Diamond Harbour Road. But the main thing is this: what is the height of it? Is approximately more than 18 meters. My lord, the Act says that it is a high-rise building. 15 or more, it is a high-rise building. So it is a high-rise building. My lord, what shortcomings upon inspection by the respondent authorities we noticed? Number one, my lord, it is a residential complex. My lord, they used the ground floor for the purpose of commercial activities, and there is no conversion. There is no conversion in accordance with law. Next, my lord, if a high-rise building is there, there is a mandatory requirement for fire safety clearance. My lord, they have annexed some images that some articles are there starting from page 71, 69, 70. My lord, those things should not be considered. Why, my lord? I asked that questions to the respondent authorities. They said that fire safety, it has to be obtained in accordance with law. They have to apply, committees there, they scrutinize, being satisfied, they issue a certificate. So there is a procedure. So simply I install some machineries, appliances, that does not mean it is a fireproof. And secondly, my lord, the evacuation process. So there is a constraint relating to the building rules of the KMC. So my lord, in it is notice, my lord, it is in the notice, impugned notice. It is annexed with the writ petition.
Page 68.
Yes, your lordship. They stated, my lord, B, small b, side open space, north 2.6 meters, south 2.6 meter, east 4.4 meter, and west 4 meter. My lord, the rule says there is no north-south, but the rule says there's front 3.5, rear 5. So there is a, and lastly, what we found, my lord, the ground floor is filled with, my lord, so many commercial and inflammable materials. My lord, that is the report I placed before your lordship.
That's correct. You have a report.
My lord, yes, I am on that point. That where is the word satisfaction? Where is the word?
No, that is with regard. That is correct. But you have passed the order. And whether the inspection at them, whether you have issued the notice with regard to this, what are the shortfall coming? Have you issued the notice to the petitioner who is the owner of the property in question?
My lord, so for the ground.
Okay, I totally agree with you. You went, inspected, found so these are the deficiency or shortfall, but whether it is not proper for the authority for taking the extreme or passing extreme order for demolition or pulling down or whatever it is to give an opportunity to hearing to the petitioner.
Since it is a 37A,
Maybe,
that is why.
maybe.
And my lord, I also found in their my lord report. I asked that questions also, but before asking that questions, I read the report and thereafter I found that some statements are there in page 3. I pencil marked page 3, my lord, of that report. They distinguished, my lord, stating the paragraph from the directorate considered whether issuance of a notice under section 35 of the West Bengal Fire Services Act 1950 would adequately address the situation. However, compliance proceedings under section 35 necessarily requires the passage of time, during which the hazardous activity would continue and the threat to the residents of the building would remain unabated. Waiting for compliance while permitting continuation of the hazardous occupancy would have exposed innocent residents and other occupants of the building to an unacceptable and continuing fire and life safety risks. Thereafter, 2 paragraphs are there. Also, the situation therefore involved much more than a mere technical or procedural violation. The findings disclosed an immediate and continuing threat arising from the operation of an unauthorized office and storage godown containing combustion materials at the ground floor of a high-rise residential building without statutory approvals and without adequate fire protection measures. Accordingly, upon being satisfied that continuation of the said activity posed an imminent danger to human life and property, powers under section 37A within bracket 1 and section 37A within bracket 2 of the West Bengal Fire Services Act 1950 were exercised. Well, that is the.
Yes. So, as per the paragraph 14 of the order, you got the order?
14
of the order. Wherein the
14
first
of the order. Yes.
Order.
At first blush on perusal.
Yes. So
of impugned order, it appears.
So where is the you have passed the order? Where from you got all these things? In the order, page 4 or the impugned order, 4 criteria you have mentioned, 4 violation you have mentioned. And this is the only order which you have produced. So before passing any order, taking any action, there should be an inspection, there should be a report. Report is to be considered by the authority. Then hearing, if you're telling that the hearing is not necessary,
that is.
If it's not necessary, then that's why can kindly come to the paragraph 14.
Yes.
What are the material before you?
Well, the inspection was conducted.
Where is that inspection report?
That inspection. Where is that inspection? I asked them.
If you suggest, if you not suggest that, I will set aside this, giving a liberty to, if you want to take appropriate action, take appropriate action in accordance with law, be giving an opportunity to the petitioner.
Yes.
Or if you want to contest this order, then you file an affidavit, then the stay will be
No, my instruction is
yes,
that
Mr. Datto.
Yes, if my learned friend agrees to that,
yes.
Of course, my lord, I
and that's our liberty.
Yes.
So,
but I cannot stop them from inspecting. But at the same time, why suddenly one building has been chosen is also required to be looked into. It gives an impression that all other buildings are fire-wise safe. Yes. And this is a 50-year-old building. And the problem is possibly elsewhere, because this company has got a unique name for your rescue. But this is a company, which distributes these fire safety equipments, and it assists the state government fire department in this matter.
But
and therefore, we have to understand
but the building is not having the fire safety.
The building is not having.
It's a high-rise building. So that's why the
Oh, I'm told you day before yesterday, another it had to be moved. Yes. But your lordship may set it aside, then
That
there.
is liberty. Yes, yes, your lordship.
That liberty is always there. Yes.
The petitioner has filed the present writ application challenging the impugn order dated 15th May 2026 passed by the Director General West Bengal Fire and Emergency Services.
Yes, sir.
Services under section 37 capital A within bracket 1 of the West Bengal Fire Service Act, directing the petitioner to remove himself and directing the petitioner to vacate and to remove the inmates of the building along with the belongings immediately until the building is secure from the fire safety point of the view as per the existing rules. Full stop. When the petition was moved, this court by an order dated 16th May 2026 has stayed the operation of the order on the ground that stayed the order and held that the respondent authorities have to spell out that inbuilt fire safety installation have been found at the premises in the question, but what are the materials available before the respondent number 2 for passing impugn order are required to be considered by the court on the next date. When the matter is taken up today, the learned counsel appearing for the state has submitted the report. But after going to the report, this court did not find whether the building was inspected, whether any opportunity of hearing was given to the petitioner, or any procedure was followed. Accordingly, this court finds that before passing any order, an opportunity is to be provided to the petitioner. Accordingly, the writ petition is accordingly impugn order is set aside. Full stop. With the liberty, full stop. The respondent authorities are at liberty if the respondent authorities intending to take any action against the petitioner for violation in respect of the said building, the respondent authority shall proceed the same against the petitioner in accordance with law after giving an opportunity of hearing to the petitioner. WPS disposal. Report most of thank you.
For respondent number 5, my lord, we have received the instruction.
Yes.
Just Secretary. Let this matter be fixed on my lord 4th August, my lord. In similar matters, your lordship fixed up the date, my lord. Just
Lordship. 40 life convicts are there, my lord. That's
in another matter, this is the order, my lord. Similar matter, this is the order.
Yes.
Lordship, last time also, when the last order your lordship was pleased to pass on 07/05/2026, lordship, a report was said to be filed, lordship. He's moved 69 years.
No, that's why cutting. Now in the 14 name, his name is also there in the 40. So
Lordship, kindly give a proper direction, lordship. Again, will take time, lordship.
No, 40, that's why already there is an order.
Yes, my lord.
his name is there. Reference WPA number.
And learned counsel for the state has submitted the report and submit that 40 live and
77.
Submit that the case of 40 live convicts are going to be placed before the State Review Committee Board for consideration of their premature release. And the name of the petition is also available in the set 40 live convicts. In view of the above, full stop. This court find that the case of the petitioner for premature is is under consideration before the State Sentence Review Board. Accordingly, for the time being, for the taking appropriate decision by the State Review Board as well as the Government of West Bengal, the case is adjourned. Let the matter appear on 4th of August.
4th of August. Grateful Lordship.
My lord, I am appearing for the petitioner. This is a case, my lord, where the petitioner's account has been inoperated by the bank, and there is a claim of rupees 1,61,254.07 paisa. My lord, the case of the petitioner is this, that the father of the petitioner was the employee of the bank, and the petitioner.
Which bank?
The PNB, Punjab National Bank. And after his demise, the entire amount was transferred to the petitioner, being the sole legal heir of the deceased father. And I have annexed the death certificate of the father, and he was died in the he was the pensioner of the Punjab National Bank. He's an employee of the Punjab National Bank at 11A, and died on 1st June 2022. And the account of the petitioner was settled. Account of the deceased was settled on that is at page 12.
So what is your prayer now?
Prayer is this, my lord. There is no outstanding, my lord.
1,61,254.
Yes.
What has happened to that amount? They have realized.
No, they have partly realized. My lord, I'm showing your lordship. Kindly come to the page 17.
17.
Yes, page 17.
Yes.
This is the pension account, and this is the account of the petitioner, and the pension account was closed, and it will be appearing from the transaction dated 3rd August at page 17. 3rd August, by nominee claim of Ajit Kumar Banerjee is 92,812 was paid. Thereafter,
was paid, it has come to you in your account.
It has come to my account.
Yes.
And my lord, thereafter, my lord, kindly come to the page 23.
70,000.
23, my lord.
23.
23.
Yes.
23, my lord. Then, my lord, 1st June. This is the statement of accounts of the deceased.
Yes, withdrawn.
1st June to 30,000. This is the cash withdrawal by certain person.
Certain person, not by you.
Not by me. This is the withdrawal, and 1st June is the date of death, and thereafter
1st June is the date of death.
Yes.
Date of death of your father.
Yes, 1st June. That is written in the death certificate at page 11A. 1st June 2022.
Yes. Then
again, my lord, 5th July. On the 5th July, that is page 23.
Yes, 5th July, 30,564.
Yes, that is the excess pension of 29 days, June 22.
It is withdrawn or deposited?
It was actually, my lord, it was taken out by the bank.
Withdrawal.
Yes.
Excess pension of 29 days.
Yes.
Correct.
Thereafter.
So you died on 1st of June.
1st of June.
Yes.
So I have already completed the month of May. So I am entitled the pension of the month of, that is 31st May 2022.
Till 31st of May, you are entitled to get the pension.
Yes. Yes. It has already been credited, my lord. That is 31,618. That is 31st May. This amount.
31,618.
Yes.
What was your? This is a pension amount.
This is the pension amount, and this is the pension account.
Correct. Then.
And this 30,000 was withdrawn.
Withdrawn by the bank.
Not by the bank, but by somebody.
No, excess pension of 29 days. The bank has withdrawn that.
That is, my lord, on 30th June 2022. This is the excess pension, and 1st June was withdrawn at the instance of the customer.
Yes, cash withdrawal.
Yes.
At branch.
At branch.
Yes, and the 30,564 as the excess amount.
Excess amount.
And 9,000, then again 3rd August 2022, 9,000 to.
So this excess amount, and my claim is that there is no excess pension at all paid by the authority. This is my first point. So this amount is not correctly charged. Secondly, 3rd August, Milord, this nominee claim paid to the, this is 3rd August. It has been nominee, Milord, just 3rd August, 92,812 nominee claim paid to the Anindo Banerjee, who is the writ petitioner.
So it was Dominic claim paid.
Yes.
So it was received by you.
It is received, yes. That means the entire account has been settled.
So 92,812 has been received by you.
Yes, to my account.
Paid to you.
Yes, which I have.
You are the Anandya Banerjee.
Yes.
Yes, then.
Thereafter, my lord, kindly come to the 30th September.
6th September.
30th September, 30.
30.
On the same page, 23.
There's no 30 September.
30th September, my lord, this PNB TDS.
Yes.
It was deducted from the source.
Not deducted. It was.
It is withdrawn by the bank. This had been deducted. Then also, my lord, on 20.
No, second column is the deposit.
My lord, this is my.
They come to the 30th September.
Yes.
32,409. That is the deposit column. That is the deposit column.
My first contention is this TDS and all, this account has already been closed. Nominee claims are settled. And thereafter, my lord, they have, my lord, kindly come to the page 24. These, after making all these deposits, and then again 50,000 was deducted, IBA group medical scheme. So this entire exercise, my submission is that when the entire claim has been already been, my lord, gone through the bank and has.
So then they have to file the report.
Yes.
You got the report?
No, Darsha, I will file a report.
Come with the report. Why the amount has been received? What is the instruction?
I want instruction is there. Mention all the amount.
Excess pension.
Pension transferred to the nominee's account.
Okay, you give the total details to him. File a report. File a report.
Account marked lien, not freeze. Thereafter, lien removed.
Okay, you total give the details. What was the amount? What has been recovered by you, and what is entitled for? This court find that.
Page 9 of the writ petition is missing. Kindly
Give the copy of the page number.
I will give.
Give here in now. And this court find that a report is required to be filed by the bank to giving the total details of the account of the petitioner, how much amount was deposited and how much amount has been recovered and released. Let the report be filed within 2 weeks. 2 weeks after serving the copy to learned counsel for the petitioner. The petitioner is liberty to take exception to the report, if any, within a week thereafter. Full stop. This is the matter on 14th July. 14th July.
Grateful.
Under the same heading.
On the same heading.
Before your lordship takes up the original side, item 27 of my lord's list, the interim order is still today, my lord.
Till today?
Till today.
Who is for the other side?
We had served notice, my lord.
Record and order. 27. Huh? 27?
May I give the notice, my lord? Notice.
Though the matter is fixed today at item number 27, but due to paucity of time, matter could not be taken up for hearing. And the counsel for the petition has mentioned the matter after notice to the other side, but none appears on behalf of the respondent. This court finds that the petition already enjoying the interim order. Accordingly, the interim order is extended till 28th of July 2026 or until further order, whichever is earlier. Let the matter remain in the list.
Milord, I am for the petition and Milord,
I am for the
Lordship's direction, Milord, the job has been performed by the land.
Submit the report. No, I am fixing tomorrow as to be mentioned. Come.
Tomorrow.
Item number
25.
25 tomorrow to be mentioned. Kar do.
My lord, may I kindly be permitted to mention this matter, my lord? My lord, this matter was dismissed for default yesterday, my lord. But I am the respondent number 4. I have my 340 application pending, my lord. There was a specific direction by your lordship that the matter will be taken up even in the absence of the petitioner, my lord. I'm just mentioning that.
What is your application?
It's pending, my lord. So
what is your application?
It's under section 340, my lord.
Huh?
Section 340, my lord. Perjury. So the application is pending. There was a specific direction by your lordship that the application under section 340 will be taken up even in the absence of the writ petition. It was dismissed yesterday, my lord, for default. The order, my lord, I'm just praying that my application may be listed, my lord. That is it.
Upload. That is uploaded.
No, my lord, the application.
Application will see to that.
My application for 340, that much, my lord. That may be recorded. Grateful.
Lordship, I had moved in the vacation bench one case to WPO 218, and that has to be listed for tomorrow. There was an order by Justice.
Of this court?
Yes.
What is the matter?
It was regarding senior citizen and some other matter. It's all in the
original site.
Yes.
Original site.
Right.
What is the prayer?
I don't have the paper today. I'm just.
You file the writ petition, you don't know. Give the number, we'll see. Give the written case number. Yes, we call the list.
Item number 1, for judgment.
Dismissed.
Would your lordship expedite the suit, Lord? Would your lordship expedite the suit, Lord?
Mention, I will say. Mention, I will.
Item number.
Yes.
My lord, in this matter, my lord, an award was passed in my favor. My lord, I filed a section 9 to protect, my lord, fruits of the award. My lord, your lordship had passed an order, my lord, on 31st January 2024.
Yes.
My lord, that's at, my lord, page 14.
Yes.
My lord, kindly come to, my lord, para 37 of that, which is at page 34. My lord, that award, my lord, had been challenged.
Yes.
And my lord, in para 37, my lord, your lordship will find, my lord, that the challenge has been referred to. And at the end of all this, my lord, at para 41, your lordship will find, my lord, your lordship appointed, my lord, para 41, your lordship recorded, we had made out a case for, my lord, interim order. And my lord, preserve the iron ore already excavated in the mines and appointed special officer. 3 things were to be done: inventory, symbolic possession, and supervise excavation of ore that is being excavated to ensure that no part of X dealt with any third party except the petitioner.
Yes.
Now, my lord, special officer was appointed. My lord, he has, my lord, we presume, my lord, that he has undertaken your lordship's directions. But what has happened in the meantime, my lord, is they have also withdrawn the 34. So there is no challenge. I want to execute the award. So my only, my lord, prayer, my lord, in this, my lord, is the special officer should file his report, and my lord, on that basis, my, and circulate copies, my lord, we can, my lord.
May I,
Sign matter. Are you calling?
may I only make one
No, this
submission,
is-
my lord? I will appear for the respondent, the award debtor. That it's a fact that 34 was filed. It was withdrawn because the mining lease has expired. My lord, there's no, we are not in possession. Now, my lord, in this application, my lord, I am no longer, my lord, instructed, my lord, kindly records this, my lord, and necessary orders can be passed, my lord, because my advocate record is not, does not have any instruction.
I'm only praying that your ID will be time for us to assimilate the documents and the events that have been carried out. So I need to also get these photocopies and scanned. Allows me 4 weeks time to come back. It's circulated.
My lord, yes, sir. My lord, your lordship can direct them, my lord, to file a report within 4 weeks and circulate it. We have no problem.
How soon? 3 weeks.
4 weeks.
This order was passed when?
2020, your lordship, I think probably not be satisfied your lordship the timeline. Your lordship, I put this specific query to my learned senior with respect to the timeline.
6 months, 2 years has passed.
Yes. So, my lord, the matter's been withdrawn, my lord, really, my lord, nobody's. So, my lord, let them, my lord, file the report.
4 weeks, I am only paying for 4 weeks. Your lordship will kindly note.
Learned counsel appearing on behalf of the special officer pressed for time to file report. In view of the submission made by the counsel for the special officer, let the report be filed on or before 23rd of July 2026 after serving the copy to the learned counsel for the petition. Leads the matter on 24th of July.
My submission.
Full stop. Mr. Learned counsel appearing for the respondent submits that he has, though he was appearing in the matter, no, he is not having any instruction in the matter.
Obliged.
Though he was appearing for the respondent, but now he is not having any instruction. Mr. That is appearing in the matter. No, because why I am telling, no, because all orders name is recording. That's why. That is. No, because I am seeing that his name is there, but his. That earlier. Yes. I am thinking where this case will end.
One of the companies they produce but they have said we haven't done this. That go. As far as There is no identification. We have not been shown. But at that basis, but in any event, this was the exact defect. When I wanted to buy identify same thing, identical defect. Because there was no commission sent to a foreigner. All that said was this money sent to a foreigner without something permission. And that when our witness was said that this was a plan, people don't go for it. Now bank is the loan that foreigner was never there. Again, contraction to it. And as far as bankers there on the law, I don't have a thing. They can't exercise a gift regarding someone else. This list of things, but the importance of it is to show why I made a counter thing. And the bank has 40 years are gone. And more importantly, what is addressed in the earliest, that the bank that they were there was the right to tell that they were compound interest. Something is addressed. In fact, on the contrary, long evidence was given that because of our RTI order, that we blocked. This book, they produced the accounting paper that shows that interest was that interest is over and over, but in our evidence, we have said that this calculation itself was also because they have taken the savings banks rate. That's compared to a fixed deposit. They took the fixed deposit. That what
Match na.
no, that's the first remark I want to make. But the facts are important for them. That they have acted wrongfully and again, second question, where they want to the fact that this fixed deposit after its cash to be payable back to me is not there. Now, if you file a fresh suit, but they would have had to file a suit that this money is owed to me, I am attaching this. But no, they come up with a suit saying that this money I have already appropriated. Therefore, that is undo my technique that was not clear up to the report, but what we were doing for that is as far as there is now the what my patients and take my dogs to ready. This is when it was a check. I'll just give one more comment for each one. We deposited the check for 20 lakhs. It was sent from our own account. It was not the money. That is the earliest they contained. Upon Ranji, who happens to be the witness's father, but they have alleged that the earliest they had said my suit is bad because they make him a father. And this book they don't make him a father. They use his name, they use his brother's name, and different other sectors are made, but they don't make them up. This money was RT agency private company. They proved it that this check was sent from their account to number one. Then on 28th November, FTR was issued, no dispute on that. Then the bank statement was submitted to show that this is the Allahabad bank statement that the money was fine. Then on 1st December, taken my law to this. We say this is just what the bank wanted us to do. In the future, we have it in the bank. It doesn't say anything more. If it was a contractual letter of the statement for sent to a foreigner, something to RTI. That is contract. This is the judgment on 9/1/1985. The judgment of against from the President of India. For judgment and eventually there's a spelling mistake of FIER, periodic expression. Means the rate of seeds and cells. So in the execution.
Rate of IRI.
FIERI.
IRI, yes. Very fast.
Very good. What was this? This fact was suppressed, was not taken by the Indian. In the appeal court, they came and showed the certified copy. There were not a copy of it. But now the certified copy has not come. But they admit, as I put it in the execution, winding up and court case. This has been admitted by them. But the practice was wound up. In any event, the specific is now applied. The money was then exhibit 4, this we have disclosed. He got hold of the plane and finally he have disclosed the plane. They could have done it, but they have not been able to show that. I have not seen it. And nor is there anything called record here. Another interesting thing sees the plane.
So what has happened to the suit?
No, because they say it's
Okay.
then the very right of the debt, that letter is the only letter they wrote the written of this debt, and because it has wound up.
What was the claim? Against the
Some money because of some this we totally explained, but I really thought it irrelevant for this suit. Because someone has my mind was there. The other came against the point I want to make about this. It does not mention that RT agencies have given a collateral of it. There absolutely no mention of that. It's not, or not that it has been given or sought. So this, as far as RT agencies is concerned, no mention of it in the case. In the letter, then the next letter, 11/2/1985, their entire case is based on this letter. I have already come to so this is the essence. Denies bank's claim against essence and demands refund of divides the Sheffield over our they have agreed to recover it. Letter they are relying on. Second, the first and and said that we have arranged for the money in this branch of the right? So they can coach. Later, there are two letters from the bank. The later letter, it will come on one.
Yes.
There, I have placed the sentence.
Yes.
Diana writes to Simmons and Simmons. Details of dispute writes that if the laptop is called by the letter of 2015, their solicitor has spoken a number denying any correction of they themselves have said there's no
That's my experience.
and if Diana had written if there is no such arrangement, then please do not obstruct the ultimate satisfaction. This is the only letter and document they have not, we are going to ask me what was the loan and ask me the details of the that you had agreed to send this money to a foreigner account, that foreigner would have paid off.
So the latter is the creature of the total litigation.
That is it. That was the thing, and that was, I have two solutions for that. One is the arrangement has fallen through as been appear from the level of the life. That we are afford, because saying that it's fallen through, or merits, the arrangement itself had fallen through. And in any event, that was even in that letter, it was subject to RBI.
Without the permission.
Now I think the limit always having $250,000. It's always nice to have that money to send.
You are thinking to send.
Now, then another comes this and the head. Now, it's my choice if I want to send the money abroad or not. I have not asked for permission. When it expires, I write to them on the right to the bank. As on this date, they have there was no RBI blocking the and nor was there any permission to allow them to transfer the money abroad. But they did not do so, and blocking comes in 86 September, much later. The RBI comes in January 85.
February.
Then, this is the letter that was not disclosed, but this is the letter that I could record with the second Zayawala. Stockton and Lampard was for the bank. And the solicitor changed to Simmons and Stockton and Lampard had written, and it is reference in Zayawala's letter of there they have said they have supported that they have said that
So it is not exhibited.
that letter was not produced. Then Zayawala's letter was produced by the bank. We have no connection. But this is referred to in the 4th of July.
Yes. No. Yes.
Then 14th of June, the bank says that we cannot release the FD contact by the 30th of June, the show that we had given the tax was our money.
Yes.
Then 4th of July 85, the Zayawala setting letter or to show that we are once before the trial. Then, since they asked us to write to Bombay, we wrote in July that Tanna writes to Bombay to request that. This gives us a first hope that this money they have already sent. The FD was back in Calcutta. They refused to produce the fixed deposit rate. It's a very important. That would have shown how the weakness of the trade. One part of the evidence that we never maintained it, but later we backdated it. But it's obviously that weakness of the trade. And why? It was already sent to international connection. We wrote to Bombay and they also have give us money. Because the next day to come to relevant and get final defense and main accounting being a Zayawala, I'm sorry, supposedly. Then this is also interesting because we want to both the and after I have made the report, somewhere in the for wrong places, they have whereas the wrong places decrease after I have created just one of So they filed an event, and on 5th of August, Bombay runs rights to us and said that let's tell until the end for against Serbia line and they asked us for instance. Because 21st of October 2008, right? Finding a order against ground case was filed. This is like some case again is not too relevant anymore. So that was the impression given. Then we the entity was matured in May. In November, the bank tried to have RBI for permission to send this money abroad. Seeks permission and mentions that wrong place has been bombed up. That's where we got that bank. So our bank to RBI that we has for set off against the amount by from SFI subject to approval. So they asked for approval. One interesting thing as far as this, the fact that we saw permission that was when capital happening. Then something else are there. That was one of that was one of the first instances of the pressure. So this case, admittedly, this had applied and November they applied that next week, 14th of January, the regulation not permitted from India and it asked for detail. Now our agencies came to the radar of RBI that is started investigating the foreign exchange violation. That's why the blocking order came. Ultimately, after 20 years, then next 21st February 86, bank responds to RBI appearance that Randeep said though they mentioned there are no common shareholders at the connection between RK agency or Ranjit Singh and the foreign they are containing first they contain the foreign of this. Then they said that was one of the ground that was young. And they also said the Serbia group of then we have disclosed accounts of outsourced Serbia not the Serbia group of companies. We have given an account to show that company and that it has different shareholders. Not that Ranjit said either as it given these documents were there from before. They haven't even made Ranjit said their one. After allegation, there are agencies and SSF. They have the answer to the bank. Deposit and the check to the bank. There's no finding that RK with the alter ego of SSF or the one same person behind the case. That finding is not there.
Yes.
At all. All it says is that this if it is not mentioned on 30th of May and and records very important. Withdrawn defense related matter, that there is no defense taken in that suit that I have already paid you. This issue was no longer an issue that
It's also a claim, yes.
the one is the earlier letter, problem is that not on record. But then when RBI asked the enforcement directorate to investigate us, on the 3rd of September, that account was open. Now this letter is important. It does not say that there should be no. All it says is it should not be about the stop that.
So if it is taken that this 20 lakh rupees is on lien, so what was the purpose for lien?
Yes, there's no consideration. If RK agency owes a debt to the bank,
Correct.
it will have a lien. Otherwise, they can make a contract. Call it a lien, but call it if it turns out to be a guarantee for the quantity of collateral that I was saying. And RBI is very clear that a Indian party cannot pay the debts of a foreign
Yeah.
party.
That was not allowed.
Correct. So the contractual lien falls and also lien.
Okay.
That is a order of that was interpreted by the banks with the sand in their view.
Yes.
That the business has got. That's why I lost out on that. This suit that the manifold scheme always wrong. I'll come to that. September 96, RBI writes to the bank to ensure no withdrawal or payment of the account and not to close or transfer. They have said not to close the account.
Yes.
Now they are working that we have not closed the account. Or at best, the bank will the evidence. Because they are saying because of this. Serial number 81. Cross examination of question.
81. Question 81.
81. Serial number.
Yeah. Acha, list of.
That is needed of numbers are there.
Yes.
Because there was restriction from the bank that this account would not carry that was a specific case. The earlier school that no interest. Then we got ultimately for a degree and they were to pay us interest but simply. Back again. Number 26.
Yes.
Then the bank, the RBI immobilized the account. And on the first branch voucher or voucher rights of for all bad and doubtful debts, including sensitive items. So it closed, but
December 86.
And in London, so they lost their license. It was told any write-off that was done must be prior then. We could not, as early as the 1st of January 87, they knew that the bank has closed and the account. But other evidence they could not give the account was
Transferred to bank.
therefore we hold off the commission. And then that happened. Equalization order was removed. So I could take equalization order did not in any effect for this order of 14th of January 86. They two separate things. Serial number 19. When the RBI refused permission to send, allow the bank to send the money to pay off the foreigners' debt. Serial number 19.
Yes. Ask the details of connection with RPA, Dimpress, whether permission obtained on leave. Yes.
Equalization order was completely separate. It was removed. Now this permission also is not required. They like the body of accounts of it. The second,
Yes. Once the account.
I don't need those. I can adjust it against the foreigners there.
Correct.
Even if it's new.
So what is your answer on that? Because their contention is that earlier it was RBI has not given the permission, so it could not be sent. Correct. And still they are that it is the figure what we say lien. And if the that close in the foreign account has been closed and it transferred to the Indian.
Written off, the profit and loss account of their branch. There is perhaps with some accounting there is SLCPLIS cost so much loss. They're really taking my money, they're not adjusting it, they're not saying SLCPLIS owed me 100 rupees and I'm taking 20, adjusting it. The debt has been written off. They just appropriate this one. And this on that, amount paying a foreigner's debt. It's a coincidence that the bank was closed and their account is now maintained in.
That's a learning.
It would still need permission, and that's all these facts. So before the thing, whatever if there was
Permission.
And since permission was not there, the bank without any answer, therefore. Denies the activity. What was transferred or what they show adjusted against the general profit and loss account. Nothing to do with particular account or account. So this is the 86, the bank closing, the accounts are. Then, 23rd February 1997, bank seeks RBI permission to payment level. 24th February 1997, bank seeks RBI permission to payment level. 25th February 1997, bank seeks RBI permission to payment level. 26th February 1997, bank seeks RBI permission to payment level. 27th February 1997, bank seeks RBI permission to payment level. 28th February 1997, bank seeks RBI permission to payment level. 29th February 1997, bank seeks RBI permission to payment level. 30th February 1997, bank seeks RBI permission to payment level. 31st February 1997, bank seeks RBI permission to payment level. 32nd February 1997, bank seeks RBI permission to payment level. 33rd February 1997, bank seeks RBI permission to payment level. 34th February 1997, bank seeks RBI permission to payment level. 35th February 1997, bank seeks RBI permission to payment level. 36th February 1997, bank seeks This is something completely different. If this law is up, as a grant of permission, secondly, they said, no, this Indian bank was sent, the central bank was sending central bank the this permission has nothing to do with arcade or with asset security. But there they have said that these are the bad debts that they had with the government or the name is there. This was produced by the plaintiff. This does not give permission. You need to go to arcade. The 9th of March, again we gave a final notice, and then this document, the next document, 32.
Yes.
32, 28th of March. This document used was that to show that they have written off the debt.
Yes.
And they are saying pursuant to this, they have written off the debt in London on 31st December 1996. And as I said to your items, it's there in the list of persons they have about 48 lakhs, and they have mentioned what the guarantor is one. The guarantor is not RBI. This was the document, this is the only document they rely on that it's got written off. According to the general profit and loss account, okay, I have adjusted. At last call, we file the 287. Then we file the chapter 30 and the 2 serial number 35 should be active. The bank files an opposition, and in this, they make several mistakes. That's not going to be. Just keep a star on the side of the list of where they have made this is kind of delayed. And they do not disclose that they have taken permission and they are already. And if I reply, they are that it was allowed and
That's the suits. Yes.
Now, 19th of April 1990.
Yes.
RBI writes, what is the status? As the RBI disclosed its file, there main inquiry has to be taken. It was 30th of May 1990. Created was informed by the that's 41. These things took place during the chapter 30, serial number 37 to 40, disclosed document section. On 26th March 91, the summary judgment was passed. Then we did an application. They made an appeal, they filed an appeal. 91, now it's 2004. So take that. And in the appeal, the chapter 30 was
dismissed.
on technical grounds that we cannot call for evidence. They called the RBI person to the box. We disclosed that there was no box. But thanks to that, we got that knowledge that there was enough. Then they filed a suit and they filed a written statement of but in said the name of either 2006 when they actually appropriate and awareness. And say, no, we have appropriated something. There's a contradiction for a bit because what fits it was in this concept. That was it. All here, state that being process that this as a paragraph for 10 capital. Original written state. I thought that was the amendment. 10 capital A is the original written state. It says that we occupy. Then 10 capital
Yes. Page. Of plaint.
One line, reference to a letter given. The advisory of the FD.
Page.
Page 15 of the additional. All I wanted to say was that profit did not mean that person, but as the food perspective and the states that already but they went ahead and transformed.
How much time will it take? Further. Next date.
I only would raise this topic that some question as well. And the
Exhibit 18 देखो क्या है? Good. Learned counsel for the defendant has argued has filed the list of dates. Let us with the record. Argued the matter at length, but due to paucity of time, hearing could not be completed. This is the matter on 8th, na? 3:45. No, yesterday I was signing. I see the name of the Mr. because somebody told he's not appearing. That's why you asked. Advance booking. Eighth and 16th. 16 July 3:45. Thursday, that is Thursday, no Friday. No, 8th he has to complete. Then 16. Come on that day, come.
number 5 and 6, which are section 25.
Third copy. Serve the copy. No. There are 3 documents you required. Correct. 3 documents you require and cannot be given due to this. No, is telling that if Asika is allowed to take to sell. No, that's why Asika wants either it should be deleted. No, because okay, let me see. Yes. Yes. Let you complete.
No, but we got. It only so that the shares are never sold and the 25% remains. And no minimum public shareholder is ever raised. That's the whole game.
Whether the share is decreasing or rate of share is decreasing or increasing.
Now I go to minimum public share. I showed it at 25%. Company will sanction the scheme. All this operating all they will never share the same. So no solution is acceptable. That's all.
Yes. Which one? Which one? 97, 91? That's why I'm asking. 91? It's a 91.
Once the infrastructure financing has sanctioned down the loop. That is SIF. Well, the question was, what other what the point was SIF and also we say that we have infrastructure investment. Let's say they are SIF by which the minimum of transfer is coming down. I find that the entire application production will be a lower time. That there was this application I learned with that. That is the primary condition for section 9. And as a matter of fact, because of the special jurisdiction, the production is the assisted jurisdiction. Because when the first branch we have to show the application, I have taken this point. Now, if they were saying a point of view or not, because that's what we see, but whether it's confusion or not, there, I don't think there is confusion. Whatever we mother, there is no application equals section 9 for so I have been given the notice for the last cases that you have. File another section 79. Sorry, section 79. Similar case, a bit more.
17 before the arbitrator. And arbitrator appointment in connection with which agreement?
That agreement.
Original. Correct.
Agree, but obviously every point, all of points are open.
Correct.
Now I file a section 60 then because during section 70, they have not produced arbitration. Before they got an arbitrator,
So how the arbitrator was appointed?
but on the basis of an agreement and their submission to that agreement, if you also can appreciate yes, there was a message. Arbitration agreement, it's a prior now, the also kindly appreciate, we have already filed a case that they filed a immediate agreement. But now they file a react but they won't file it. Then they file a react agreement. And under section 6 is also filed in the reform. So the question will be of the arbitration agreement. The arbitration is now waiting to come up. Where they also filed another section 7 application. Asking for more than what has done before your also. So, in the case of now, they are here also. They are also. Now, whichever form is there, order. But I have made a submission to the law that once the driver has been
having yes.
And this matter, I am just start finding it. If I said, driver is already there. And I friend almost say that who want the same of the dead. Where I said, stand on I have said that it's an institution. You do not have a degree in your giver, award in your giver. But that because there was an order for sale. Yes, let you put that in. But it is not something which are required to tantamount to first adjudication that you have a claim of 600 crores against me. I will suffer an award and you must get the money.
Yes.
Now, to reach this conclusion, there obviously arises agreement. Now they have sought to refer. Start on page 41.
Of your opposition? Today, that's why. So you have a pain, then you have to purchase the medicine. You have pain, and then you have to purchase medicine. Yes, where is the application?
The petition also, paragraph 6 of the petition. It says, in the meantime, by a business transfer agreement, page 5,
Yes.
in the meantime, by a business transfer agreement of 16th August 2019, entered into between the said SIFL and the petitioner, the lending business of SIFL to transfer to the petitioner and thus the petitioner was considered the lender for the entire loan facility of the responsibility of underlying contract. What they get? Lending. Agreement, they get it. That's what they say. Assignment. Now, kindly, since we are on this further, kindly straight away come to paragraph 6, where we are looking at this petition. The said SIFL had filed, and now
Yes.
SIFL had filed.
Yes.
An application under section 9. When the respondent's question will be included the same on the website. The said SIFL, upon considering the facts and finding that the resolution tax to the proof by the resolution has affected the resolution, also they will do agree. I am talking about SIFL, not ECF. SIFL filed, your loan has been assigned, that's what you're saying. So they consulted and said, okay, they will not proceed to the section.
Correct. Because of
They find this section. Now, kindly see, paragraph 22 onwards. First, your lordship will find it is evident from the conduct that the right of petitioner and deputy to action which is in 23 implies to make payment of 600
yes.
implies to make payment of 633 crores.
Yes.
Not 20 as such.
Differences.
Disputes and differences are very simple. It is a party. And such disputes are covered by arbitration clause contained in clause 8.4.1 of the Common Law Instrument dated January
2008. 15 2018.
Yes, sir.
15 2018.
But that is not important. The importance is, if you are referring to this Common Law Instrument, they must show that this is an arbitration. Now, the Common Law Instrument, I don't need to show that. The two parties there is SIFL and me. So they do not anyway say that there is an equity given. Now, my dear option is very available. Arbitration agreement is an agreement in itself, independent. Now, it is when it gets said that there was an assignment of the arbitration agreement, I don't understand. Nobody argued. But the initial part, they have also taken this part of opposition. It is not going to have like arbitration. The initial threshold is for them to show that there is an arbitration.
Yes.
Other than the paragraphs which I have shown, the lordship will not find any other valid argument per se which show that there is an arbitration agreement. Now, let us see the business transfer. Because I am taking the best view, but they have nowhere as yet anywhere said that along with the business transfer agreement, there was an assignment of the arbitration. There is nowhere said. So when they do not say that, there is no arbitration. Now, even I am giving them a benefit. Now, let us go to the business transfer.
Yes.
But this business transfer agreement is possible. This business transfer agreement between this is SIFL and SC. Transfer and transferation. And I will tell the transferation. I don't know the rest of the redacted portion, but whatever they have given us for it. But they said that they can't give the entire redacted one. They gave us this what they designed. But it's something that they would like to disclose to us. That's what they said. Now, let's see what is it that they were transferred. See, when I see the set, what you see, the transfer, balance of transfer, the transfer undertaking as defined here under, and the transfer is entirely acquired the transfer undertaking on an as-well basis as a going concern by the Kindly see, my lord, 1.1.2. Agreement shall be transferred agreement and includes all attached and schedule modifying or conforming. Now I have the logic the next is the document important, but only logic 1.1.9. And several organizations portfolios are being transferred from all identifying the contracts. And this is page 1.
Yes.
Contract include all the benefits of issue or contract of all nature.
Yes.
Whether you know transfer business and transfer warrant undertaking to and warranty there the life debt valid and subsisting another coding rate. Obligation of the passport business transfer. So it is only related to the PTA. The PTA, whatever they are. Now I'm trying to put. Kindly comes to page 49. At the very beginning, the result that showed it was transferring of undertaking. Now kindly see Scotland. 1.1.5.
Yes.
Transfer undertaking less to the transfer. All assets schedule 1. Include the assets most present. Schedule 3, schedule 4, and schedule 2.
Yes.
And next page, all liabilities schedule 5, 6, and 7.
Yes.
Kindly comes to page 8. This is schedule 4.
80.
8.
What you will got? 80?
Only place where your lordship can people tells us. A96. 1 loan, 565. Now that is only case where I am mentioned. So it's under the heading list of financial assets.
Party 65.
So that's what they are mentioned.
Party 65. How you identify yourself as a part? How you identify by this?
So yes, then they will only keep those which are part of the. So everyone else will be that. So I keep that.
Acha. Because they're not deleted, that's why it is you only.
Contact number 1. I am just arguing whether I am. Now I can see whether page 51.
Yes. Yes.
Transfer undertaking litigation.
81.
51.
Yes.
This is the transfer. A transfer and proceedings of consular nature. Civil criminal action application. Entire time is here in the application. With respect to any transaction entered up to the date before it is calculated constitution authority. Or as more specifically mentioned in the. So these are the only ones which transfer. Schedule 12. Now time is schedule 12.
Yes. Between the
other than that, there could be one more artificial provision.
yes, sir.
First point, there is no arbitration. Second, there is no assignment of the arbitration equal between SIFL and my company.
Yes. If there is no assignment itself, then
Because the logic they have asked, they have only said the transfer of the that is in conjunction and synchronization with their PDE balances. But I said these are two different agreements. You must have an arbitration clause. But what is getting the arbitration? But not an arbitration. Because when it's a contract in person, particular contract particular. Yes, I think. This is a document. Next year,
it is reported. Yes, yes, no problem. No.
But here there was an assignment. And the question was, would the assignee have the right? But here was the article from the person concerned, it is assigned the there was we find even prior to the respondent to the variable part of the contract. If we say that no, according to the respondent, I think the documentation HPCL was not about. So let us something SIFL and me was not about. After obtaining the contract from HPCL, appears from sometimes from integrated test of transport and cross road also kind of 31. Further, certificate ADC and BCA. And we will take an arrangement that ADC will actively ADC from HPCL and transport and assign the respondent BC. So that's that statement. These are the arbitration. Or the BC was a variable part, the agreement between HPCL. One of the facts of this here or he has not been expected to price. There was an intention to buy BCA the contract with the HCL. These are very meaning. This doesn't need a stable subsidy.
So why you are not challenging the first order? No, the first Justice Bhattacharya order.
Now they are pushing for everything. Beyond the ombudsman and from somewhere Ashika came and started out.
Ashika always there.
No, but Ashika came. But they still, no, I have never understood. But that guy get quiet. But today I was not in the even telling each other that was And I never put so much somebody in my life.
Actual argument and upon you, when the actual argument.
Yes, very well. They are fighting it out. After it's not being made a part of it, proceedings that they are a part. I think they are a part.
Okay.
Now, we are in the threshold of the maximum. There was time that settle or not settle, whatever it is. But now it's going too far. And my right there, since you are Ashwa, the quality has now gone down. Very good. Very good. But as a matter of election, there was a different way. There was a second divide that there also there were objections and that's very happened. One obvious what do you see? We had a similar guy comes to the last paragraph. We have kept the exam in terms of the score. In ASF, they got into one. We hope that the score in ASF, again, I should find the ASF. Now, 37. You are not impressed with the argument that the responding of the right for the Indian bidder in the tender issued by the applicant, despite being an answer, the respondent was a person gaining through or under age. Relaxation triggered of Coxon is completely understood. As held in Coxon that was no counter. Mere legal commercial condition is not sufficient for a non-signatory to claim through or under a signatory. One part of it. Then when it comes to third claim, and I'm not looking Coxon either. I don't want to waste so many have sure. Apart from the authority, not only has the respondent not shown any consent for assignment as required. Under clause 3.17 of the data document, nothing in the draft has shown to establish there was the semblance of an intent. The respondent is really granting the contract. I don't want to indicate that the respondent was a very good. So another thing we take from here, they need to consent for assignment if they say that they're going to assign. Because an arbitration agreement is an agreement in person.
Correct.
Either I choose to go to arbitration with him, but that doesn't mean that I like him. I will not do it. So that is the reason. Now, in these circumstances, I will again seek your option. Again, note which agreement has been sought to be invoked in this section. And is similar. You only talks about the common law agreement. That's it. And this is costed. Why I'm saying that? There are treaties below. If it becomes hyperlocation, where there is an arbitration, but not the common law agreement. Now they cannot say that the become hyperlocation is an arbitration law, therefore that's one plus something. Well, no, because they have invoked the common law agreement. Common law agreement.
Loaning.
So they cannot now say, no, whatever I find, that becomes the agreement. No, it is not. So this is my first point, that there is no assignment, there is no arbitration agreement. That's the first contingency, assumption, and action has to overcome.
Yes.
Now, madam, let us come to the proceedings.
Yes.
But may I come back to paragraph 7
Of?
of 1891, not that 1891.
Yes. Paragraph?
While the respondent need to create pledge of shares as promised, subsequent responsibility to the petition again are deed of hyper. Another common loan gets transferred to the private. Taken in touch with the deed of share. I'm not disliking him, I said, deed of hyper is made under an arbitration, but knowingly, but they did not enter into any arbitration agreement. It's a common non-agreement, but they were entitled to. But they did not, because it's a question of assignment.
Correct, I understand.
Now what can you see? Paragraph 11. Case made up for orders on. When it's a verdict case, we are obliged to take care of the secret.
23, 24 you have placed.
Not so the share. People to say by orders being passed in the company. I refer them. But again, this for the the Lordship remember the code that's complete the submission. If the person has to get with the IPC, everyone soon say, as a matter of fact, Ashita came to my there was a suit against Ashita. And by orders of this court, Ashita was
Correct.
so, I was always trying to send the share that came in here. It's not nothing wrong with that. That is the reason why when the first order was passed, we thought that by an order now God also got they will agree. But when they found favor, and when they said, no, we are not going to do it. There are orders. There's a division bench, there's a single bench, your lordships. The first order, ask for doesn't work. And for that, I will here. And that is the reason why the shares to be declared. So this is not the earliest. Then we see petitioner would lose security because the shares several other creditors. And unable to pay the case, we end up with security. This is paragraph 26. Which became a no, as long as a submission. There is no validity of this statement. But there is a very recent submission, affidavits of submission about you will have to have against the and we can easily stand with the submission. They were very well aware, that's why he said they were aware, the shares are still there. They also knew on the price.
Yes.
And then 27. Now when it comes to their case, but I'm only on that. You're going to take your lordship and ask the difference. What is the value of the share? I answered your lordship. But that is their obligation, which again that is not what they said that they are not value. And I have shown in my opposition, the value was still there.
Yes.
Paragraph 27, page 12. middle of the paragraph, there is no dispute by the respondent. The value of share mentioned and are far less than. Particularly since such share is responsible. And when I have shown in the officer, I will show you the lease. Specific from Marat stock statement, the rates are still there.
That's why, yeah, due to the change of circumstance, what is the same?
Until now, because I can see a Marat has been admitted as well before. So there is an agreement.
So what will happen then? CIRP proceeding?
And let's hope that it is not. Yeah. It has gone back. But I don't have a role there. I don't have a role. And the only role could be that I have to put a lot of valuation. Other than that,
Okay. No, that's correct. What can be done? I have to accommodate all. Land Council for the respondent has argued the matter at length, but due to paucity of time, hearing could not be completed. Full stop. Counsel for the petitioner prays for extension of the interim order. Interim order is extended till the next date of hearing. This the matter on 20 July. And open लिखो supplementary affidavit filed by the petitioner respondent kept with the record. उससे पहले नहीं है, कुछ नहीं है. 20 जुलाई से पहले 20th July. Now what will happen to the our High Court? Nobody, huh? Respondent. 20th July 3:45. Yes. What? He wanted to that, we will see to that, because I don't want that. Yes.